Yes, brother. My lord, a POXO case has been filed due to misunderstanding. Now the parties have executed on deed of settlement. So it may kindly be listed tomorrow. Madam. We have annexed the settlement also.
Okay.
Highly obliged.
Well, item number 69, which is the I for bail of the accused. Who is bail for last week matter was left over in court number 11. Today it may be taken up at 2 p.m.
No, not at 2. As per on its own turn. We'll go serially. Not at 2.
At 2 p.m.
No.
It is not reached today because last week it was not reached.
No, we'll see whether it reaches or not.
Because long vacation is there, it will not reach today. He is in jail for last 5 months.
No, not at 2. As per its own turn, we'll call it. Yes.
Yeah, please, Your Lordship. I beg to mention on criminal petition for orders column. Any date may be given before petition. Item.
Pray before registry. Pray before registry.
I have already approached my lord. I have already filed the application. The field date, the matter.
On a date to be fixed by registry.
Any date may be given.
You go to the registry and say that court has said it to fix a date.
My lord, I want to similar quashing petition value. That will be listed next week in Interim.
Pray before registry. Let registry may fix. Yes.
Malad, I filed a new case on Monday. Malad. Next date before the trial court is on 19th. Malad, it has not been listed. A new motion. The lordship permits me to move it tomorrow. Or at the most, Malad, on that Friday. The trial court date is on 19th.
Friday.
Friday. Obliged.
May I please, Your Lordship? Lordship, in item number 24, there is a typographical error, Lordship. I may be allowed to correct it. It's just a digit, Lordship.
You file the. You want to make the correction by hand. But
Lordship, it should be 34 and it is written as 24.
okay, do it.
Highly obliged.
May I please, Lordship? Like one bail hearing matter that was posted on 11 and 9. On that day, Lordship, the matter was left over. And till date, Lordship, not listed.
Next week on a date to be fixed by registry.
Can it be on Friday, Lordship?
No.
Then on Monday, Lordship.
You pray before registry. We don't know the board. If we fix without knowing, then again it will be left over. So you pray before registry.
Please, Your Lordship. I beg to mention item number 61. Kindly matter may be taken up at 2 p.m.
No. No. Serially. Yes.
May please, Your Lordship. I beg to mention for listing of criminal revision petition, my lord. The day before yesterday, Lordship has directed ST to list the matter today. It was the NI connected matter, my lord. The petitioner has been behind river for the 144 days, and the both parties that amicably settled this. And there is no the statistic grievances I can take execution.
When do you want?
And it was directed today. The order past value Lordship on the day before yesterday. Tomorrow.
Okay, tomorrow.
Please, Your Lordship. I beg to mention item number 26. Item number 26.
Yes.
There is some difficulty on the leading council, on the part of the leading council. It may be taken up next week, any day.
Heard Mr. B.J. Talukdar, who prays for an adjournment on the ground of personal difficulty of the conducting council. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, Your Lordship? I beg to mention item number 43, Lordship. The case diary has not been received, Lordship. It is not reason.
Heard Mr. V.H. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, who prays for yes, some other date for producing the case diary. Prayer is allowed. Let this matter be listed on 29th of October. 29th of October. The interim order shall continue till next day.
Deeply obliged.
Yes, your lordship.
Just a minute, Kim.
Yes, your lordship. Listing for withdrawal lordship, I want to withdraw the matter. Approval lordship.
Tomorrow.
My lord.
May it please, my lord. Prayer for upgradation of one matter, my lord. Item 41, my lord. In the second half, it may be taken. My lord, I won't be here, my lord. That is why I'm saying I'm the conducting counsel, my lord. After 2 p.m., my lord.
Okay.
I'm deeply obliged. 41. Item number 34 and 35, my lord. These are connected. Item 35 is a bail matter, my lord. This effectively deals with, my lord, default bail. So this matter has been pending for a long time, my lord, but because there is a connected criminal petition also, my lord, it has come in the admission column, my lord. But it's effectively bail order. Item 35 is the bail application. My default bail was, I'm entitled to default bail, I have to get default. That is the issue, my lord. So after bail hearing matters, my lord, if possible.
Okay.
I'm deeply obliged.
After bail hearings, 35.
Deeply obliged. One motion mentioned for withdrawal, my lord, tomorrow, my lord.
Okay.
Yeah, please. I beg to mention item number 54. My lord, wrongly listed, my lord, this is Division-based matter, my lord. There is a life imprisonment. 54.
54 has been wrongly listed. Why?
My lord, this is not a life imprisonment. Punishment is life.
Okay.
imprisonment. So it should be good.
Heard Mr. D. Gogoi, learned counsel for the applicant, who submits that this matter involves punishment up to punishment of life imprisonment, and it should have been listed before the division bench registry to verify and list the matter accordingly.
Deeply obliged.
Need reservation. Actually, I beg to mention for listing for IA, my lord. After vacation.
After vacation, why mentioning? You go to registry, pray before registry.
For a date, my lord.
Yes, you pray
Okay.
before registry.
My lord, item number 27, prayer for Passover. My senior is traveling out of station. So is it possible for 19th of September?
No, please. Item number,
27,
what is your name?
A Deka.
Heard Mr. A. Dekar, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Matter is adjourned for the day.
My lord.
Yeah, please, Your Lordship. I beg to mention for listing of the one interlocutory application in connection with criminal appeal number 41. Lordship.
Next week, on a date to be fixed by registry.
Lordship, Monday. Lordship.
No.
He is behind the bar for last.
Let registry decide.
That
Yeah.
may be fixed, Lordship.
After,
Next day.
after puja vacation at the date.
The 24th
27 October,
24th of September, Lordship.
27 October, or you pray before registry.
Okay, sir.
May it please your lordship, I beg to mention for listing of a BA, bail application,
Fresh matter,
no fresh matter, bail hearing matter.
next week on a date to be fixed by registry. Registry will be fixing date.
May I please,
Yes, Your Lordship. I beg to mention for a listing of a criminal petition, Lordship. It was long pending, Lordship. It was listed on 5th of June, Lordship. Kindly fix a date, Your Lordship, if possible.
Date to be fixed by registry next week.
Next week. Obliged.
may I please, your lordship. Lordship, I beg to mention for listing a criminal appeal, lordship. Last 3 occasions, lordship, service was not completed to the respondent number 2, lordship. But as per my information, lordship, service is completed. So it may be listed in order column, lordship.
Next week, on a date to be fixed by registry.
Please, your lordship, I beg to mention item number 37 for adjournment, your lordship.
You have
37.
informed the council for the, you haven't heard Miss
P. Upadhyay, your lordship.
P. Upadhyay, learned counsel for NCB, who prays for an adjournment. On what ground,
Yes, your lordship.
what ground you are seeking?
File objection.
Prays for an adjournment. for filing written objection in the case. Also, Ms. N. Sultana, learned counsel for the petitioner. When
Next week, 25 or 26, Lordship.
26th, Lordship.
let this matter be listed on 26th of September.
Wait, please, your lord.
Yes,
38 petition of council on discernment.
38 will fix the same date when the matter is called. Yes,
May I please your lordship? I may be allowed for withdrawal, a criminal petition.
tomorrow.
Prayer for listing of an IA matter. Commercial quantity NDPS last listed on 3rd of September.
Next week on a date to be fixed by
Day
registry.
after tomorrow, madam.
No. Next week on a date to be fixed by registry.
Monday.
No fixed.
Hello.
May it please, your lordship, I'm praying for listing of a regular bail application, my lord, for Friday, my lord, if possible.
Next week on a date to be fixed by registry.
Lordship, lordship, I beg to mention for listing of IA, lordship. There in this case, lordship, there is 3 applicant, lordship, and out of 3, lordship, 2 already got bail, lordship.
Next week
Next week, there is
on a date to be
any
fixed by,
date, lordship.
let the registry fix the date.
Deeply.
My lord, I'm praying for listing of IA for modification of order, my lord. I'll let you occasion it was not reached, my lord. Only modification of order.
What modification?
Uh,
There is
name
an
of the
error,
petitioner, error in the name, father's name.
error in the name. When do you want?
Tomorrow or day after? Tomorrow.
Yeah. Okay, tomorrow.
May it please your lordship. Lordship, I praying for listing a criminal revision petition, lordship, which I have already mentioned on Monday, lordship. It was to be listed today, lordship, but why it is not listed, lordship? I'm unaware of, lordship. Can it be on tomorrow, lordship? Because NBW has been issued against him, lordship. Matter relates to NI case, lordship. Negotiable instrument case.
Okay, tomorrow.
Oblige your lordship. May it please your lordship. In mentioning a letter application for AB matter for listing tomorrow or Friday, lordship.
Fresh matter.
Fresh matter,
When have you filed?
yesterday.
Friday.
Oblige.
One promotion.
Lordship, charge sheeted matter, POCSO matter, earlier, lordship, notice was issued, lordship, but TCR was not called for.
But the service is awaited.
Also, TCR has to be called, lordship.
Heard Mr. PP. PP Medhi. PP Das, PK Das, learned counsel for the petitioner. Also Mr. KK Parashar, learned additional public prosecutor. The office note dated 13/22/8/2025 shows that the service report of the notice issued to respondent number 2 has not yet been received. The learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed. The scanned copy of the trial court record may also be called for registry to take steps for requisitioning the scanned copy. Let this matter be listed after 2710.
Oblige.
Yeah. Bail application, lordship, POCSO is there. Yeah,
Also is there, heard Mr. M.K. Neog, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. It is pending investigation.
No, let
Let the scanned copy of the trial court records along with the connected scanned copy of the connected case diary be called for. Let the notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on, can give a date, 29/10. List accordingly.
May I please, Your Lordship, Lordship 483 application, Lordship. FIR is at page 18, Lordship.
POXO,
Oh, not attracted actually, Lordship. FIR is at page 18, Lordship.
no, no,
There was just a small fight in the marketplace. The case is behind the bar since last 26 days.
what is your name, Gopal?
Okay, Lordship.
Where is the vernacular?
Vernacular is 20, Lordship.
Why the case has been registered under POXO Act?
Lordship, see, this case, FIR was filed on 7 August. Case is registered on 21 August, Lordship. And moreover, we also have filed.
We'll fix
lodged an
it. We are not issuing notice. We are fixing a short date for case diary.
for this.
Okay. Heard Miss S.E. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner submits that though the Satgaon PS case number 153/2025 has been registered, inter alia, under section 10/12 of the POXO Act. However, bare perusal of the FIR indicates that no accusation against any offense under POXO Act has been made therein. Stop. Let the case diary be called for.
25th.
Let this case be listed on 25th of September.
Obviously.
Right, your lordship, ma'am. My lord, in this case, your lordship will find suspected to be ganja. Commercial quantity. Just I take the lordship to only page 30, my lord. Your lordship will call for 35. Page 301. 48 notice, ma'am.
Yes.
Your lordship will find address to committee, my family. And your in the bottom, your lordship will find my signature was taken, my. It was never communicated, my.
We'll find from the case diary.
That's.
My lord, with all respect to senior, my lord, this case, my lord, the respondent, my lord, given as a Union of India, my lord, Ministry of Revenue, Ministry of Finance. It should be customs, my lord. Ministry of Finance cannot, my lord, bring the CD. Page 30, my lord, officer, my lord, custom preventive force.
Or DRI.
DRI or custom will be, my lord, but revenue, my lord.
Madam, Union of India will serve the copy to him, madam.
No, Malad, there are separate councils. I can appear for Union of India when Minister of Finance is there, but I cannot bring CD from customs or DRI. I am not the standing council, Malad. So, Malad, it
No,
should be,
what is the case number?
Malad, in the
NDPS is not clear. No, finance, no,
it should be, Malad, customs or DRI, Malad, but we don't know. Yes. Malad, place of arrest.
Customs department.
Customs.
It will be customs, madam.
So customs standing council has to be, Malad.
Yes, you
I
have
will
to
serve,
serve.
madam, your lordship will correct it, madam.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned edition. No, no, I will make it clear. Mr. K.K. Parashar, learned Central Government Council, who submits that this case pertains to a complaint filed by the Custom Preventive Force Silchar, and therefore the opposite party is to be shown. The opposite party, that is Union of India, is to be represented by Customs Department, of which a separate standing council is there in this court. Considering the submissions made by learned counsel for the learned Central Government Council, the learned senior counsel submits that the petitioner may be allowed to amend the cause title of the instant bail application. The prayer is allowed. File tomorrow or day after tomorrow. Amended cause title.
Amended cost item.
Then we will issue notice. The prayer is allowed. Let this matter be
By
listed.
hand also you can carry. it
No,
also.
no.
Hello. All right. Tomorrow.
Let this matter be listed tomorrow again. In the meanwhile, the petitioner may file the amended cause title.
Chargeable matter, Lordship, for regular bail.
Heard
Lordship,
Mr. D. Mehdi, learned counsel for the petitioner. Also heard Ms.
P. Upadhyay,
P.
Lordship.
Upadhyay, learned counsel for NCB. It is pending investigation or
No, Lordship,
charge
chargeable.
sheeted.
Lordship. Similar matter, Lordship, already TCR has been called for, Lordship,
When?
bail application.
When?
703/25.
When is the date?
Lordship, this fixed after a week, Lordship. Next week, Lordship. Fixed date was not given, Lordship. Registry was supposed to fix the date. Lordship.
We'll fix it after vacation.
So can it be tagged along with the bail application, which is supposed to be
Learned,
come up next week?
learned counsel for the petitioner has submitted that in a connected case, that is bail application number
2703, Lordship.
2703/2025 case diary has already been called for.
TCR, Lordship.
The trial court, the scan copy of the trial court records have already been called for, and same is listed after a week. He prays for listing this matter along with the said bail application. The prayer is allowed. Registry to list this matter along with bail application number
2703.
2703/2025.
Deeply obliged.
Maybe, Lordship, there will be required, Lordship, though they connected, earlier arrested accused person already been granted bail, Lordship, in this case.
Heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the case diary be called for.
It is available actually, Malad, it can be fixed on Monday.
Let this matter be listed on 19th of September.
Can it be, Lordship, much obliged.
It is also suspected cases, so
Heard Mr. J. A. Ahmed, learned counsel
go
for
ahead.
the petitioner. Also heard Mr. K.K. Parashar. Let the scan copy of the trial court record along with scan copy of the connected case diary be called for from the trial court. Let also notice be issued to respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable after vacation.
It may be before vacation.
Now, before vacation, it may be difficult.
Yeah, take a chance, my lord. Otherwise, it may be after vacation. 26.
Okay, 26/9.
Hello.
Made, please, your lordship. Lordship, this is a regular bail charge sheeted case, lordship. Last 7 months, he is in jail custody, lordship. He approached before this court earlier, lordship. In the meantime, charge sheet submitted. This court has directed to approach the court below, lordship. Accordingly, he approached the court below, lordship. His bail payer was
After
rejected.
charge sheet, you approach the trial court.
Yes, lordship, that is on page 30, lord.
What is the stage of the trial?
Lordship, witness is not turned off till date, lordship.
Let the,
Charge
let
sheet.
the victim be examined. This is a
Lordship,
rape case.
Rape case, but lordship, one thing, lordship, we appreciate, lordship. Although allegation is rape is there, lordship, she was, thereafter, lordship, she was, this petitioner dropped her, as per her allegation, dropped her to her house, lordship. There is some doubt, lordship, regarding lordship. Had it been such a thing?
Yes,
lordship?
Mr. Parashar.
Now, my lord, scan copy with the CD, my lord.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Let the scanned copy of the trial court record along with the scanned copy of the connected case diary be called for. Let this matter. 30 October. 30
Can
October.
it be lordship before vacation?
No,
Lordship?
no.
26 is
No.
the date, lordship. Several
In
they have
in
not
the
turned off,
meantime,
lordship.
in the meantime, victim be examined, my lord. Perhaps, my lord,
Next date is 26.
Because unless victim is examined, it is unlikely that you may get paid.
Can it
So
be shorter, lordship, because of 30 is too long, lordship. Already 7 months in jail, lordship.
27th October.
Obliged.
Wait, please, your lordship, this is a boxer matter and steps have been taken, your lordship.
office
Supplementary
note
list,
there,
very-
my lord, as per the office note, my lord,
Get a
it's,
printout.
services awaited.
Your lordship, on the last date, this court was to be apprised. regarding
Yes,
the Service.
My lord,
you
we have
take information.
not received actually, yes, we have informed.
No, you may take telephonic
My lord,
when
my lord, fiction 19, my lord.
19. Heard Miss M.K. Brown, learned legal aid counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, who seeks some more time to take information regarding fate of the notice issued to respondent number 2. The prayer is allowed. Let this matter be listed on 19th of September.
Item 9.
Made, please, your lordship. So, 482 application, lordship, FIR, lordship, may kindly find at page 9. Both informant and the accused person are married persons. They develop some love relation. Thereafter, the informant borrowed some money from the petitioner. The money was not paid in time. Thereafter, this allegation was brought, lordship.
What is the accusation?
Acquisition, lordship, 308 subsection 5 is there. Extortion by putting a person in fear, lordship. And
Extortion by putting a person in fear.
lordship. 61(2) is criminal conspiracy. Well, lordship, the allegation is that the person made a video call to the informant. Thereafter, the allegation was brought, lordship, on mobile phone.
Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, considering the nature of acquisition leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary.
In the meantime,
No,
16th,
let this matter be listed on 16th of October.
deploy.
May I please go ahead? Lordship, this is the second pre-arrest bail application before this honorable court. And as
It's pending investigation.
pending investigation, as because Lordship, the other,
What is your new ground?
my new ground is Lordship, the co-accused who was previously arrested pertaining to this case has already been released on bail by the learned trial court. This is the certified copy of the bail.
But
And
how
further Lordship, the charge sheet which ought to have been submitted by this time, because this is a non-commercial quantity of case. And FIR was registered in the month of June. So by this time, charge sheet ought to have been submitted, which has not been submitted yet.
that cannot be a new ground.
And further Lordship, the co-accused who has been already released on bail, he has been released on bail due to discrepancy in the sampling procedure. Even if Lordship, by any stretch of imagination, I am arrested, this ground of discrepancy and parity will also extend in favor of me. And further, by this time, investigation ought to have been completed.
Heard Miss S. Kaur,
Albany.
L. Bonik, learned counsel for the petitioner. Also heard Mr. K. K. Parasha, learned additional public prosecutor. As this is for the second time, the petitioner has been approaching this court seeking anticipatory bail, while her earlier bail application was rejected after perusal of the case diary, perusal of the case diary would be
After the
necessary.
3D marathon.
Let this case be listed for
23rd
23rd of
October.
October.
Lordship, a little short day for this.
So that before vacation, it is not possible. 17,
Before 23rd,
17 or so.
yes. Let it be 23rd of
23rd.
October.
May please your lordship. The second application, earlier application was filed, rejected at page number 25. The new ground is the petitioner here is represented by his father. He is a juvenile, Your Honor. That plea was not considered by the investigation authority, and accordingly charge sheeted laid before the session court, and session court issued notice and against him, Your Honor. But that plea was, though the father of the petitioner placed the birth certificate before the investigation authority, that was not considered, and even not informed to the concerned court, Your Honor. That plea was for the first
Now, whether charge sheet has been laid,
time, Your Honor.
then you approach the trial court.
That is, I may be allowed to file a appropriate application under section 9 subsection 2 to claim my juvenility here.
No, whatever plea you wish to take, you can take it before the trial
But
court.
as I have shown absconder, so there is a possibility that
Even if you are shown absconder, the trial court will be issuing notice, summons to you at the first instance.
normally if I appear before the trial court, showing me in the absconder, normally I may be sent to the jail, Your Honor. So I may
Heard Mr. P. Neve, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by the petitioner, namely Sorfat Ali, who is apprehending his arrest in connection with special POXO case number 10/2025. Learned counsel for the petitioner has submitted that in the aforesaid case, charge sheet has been laid under section 296/351 within bracket 2/3 within bracket 5 of BNS, read with section 12 of the POXO Act. He submits that the name of the petitioner has been shown as an absconder in the charge sheet, and therefore you have received summons.
yet not. Someone is to had order at 1/9/2025. Next date on 29/10/2025.
Yes, submitted that the petitioner has not yet received summons from the trial court. However, he also claims that the petitioner is a juvenile. Petitioner is a minor, a juvenile. So, in this case, though petitioner has been shown as an absconder in the charge sheet, however, the court before which special POCSO case number 10/2025 is pending is a court of sessions judge cum special judge, and which is competent to grant bail to the petitioner on his appearance before the state court. Moreover, the petitioner may also take the plea of juvenility on his appearance before the state court, and the court and the trial court would be duty bound to consider the plea of juvenility raised by him. Under such circumstances, this court is of considered opinion that presently there is no apprehension of getting the petitioner arrested in connection with the aforesaid case. Stop. This case is therefore, this anticipated bail application is therefore disposed of with an observation that the petitioner may appear before the trial court on the next date fixed or on receiving on summons from the said court, and may file an application for regular bail before the said court if so advised. The petitioner may also take the plea of juvenility before the said court.
Public.
May I please, this for second occasion, my lord. The lordship was pleased to pass interim order on the first. This page 23, your observation has been given by your lordship. Page 24. The case is that some allegation has been made. Page 24, that part that the petitioner is a managing director of Diligent Academy, took some rupees from the students for registration of their admit card or for appearing examination and all. This allegation has been made.
Page
Now-
24.
Yes, page 24.
Your earlier anticipatory bail application was rejected.
But yes, rejected on the ground there. The point 1 of interim order was not complied with. That was there is a point 1 that is your lordship by page 25. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case. In the interim order, it is given.
Now, whether the charge sheet has been laid,
No, charge sheet not late. Now, the petitioner, after that petitioner has appeared before the IO and also given the statement. Now, this very much that whatever the IO has, PP has submitted before your lordship, that he has given threaten or inducement, whatever it is. Page 9, para 9, I have stated, madam. Para 9, page 9. That the petitioner makes to state and submits that after dismissal of anticipated bail application number so and so before the High Court, he inquired about the FIR. They have said that I have threatened, so second FIR has been filed. That is my lord, the submission made by the PP. There is no second FIR. I have inquired about the FIR dated 1/9/25 for obtaining certified copy of aforesaid FIR. Then he come to know that informants have filed a bail objection in Tarabari PS police station instead of honorable court. Bail objection he has filed there, in the police station. That is the thing. No FIR has been registered.
we are calling for the case.
So,
Not Mr.
Yeah, all along he was in interim and
B.
his
Sinha,
wife is in the advanced stage, my lord.
B. Sinha, learned counsel for the petitioner. Also Mr. K. Parashar. This is for the second time the petitioner is approaching this court seeking anticipatory bail. On earlier occasion, though he was granted interim protection, however, same was ultimately rejected on the ground that he tried to influence or threaten the informant. Considering the above facts, perusal of the case diary would be necessary, hence call for the case diary.
Well, he's all along, his wife is in the advanced stage.
25th,
My lord,
25th 9.
interim, any interim, any.
No, without perusing the case diary,
All your lordship will, my lord, because on perusal of, if it is found that there is a threat or inducement, you also reject them. So few days only. my lord.
it was
Because
rejected.
wife is anything, my lord, there is a medical certificate I have given, my lord, last page, my lord. Because if anything happened to the wife, he has to go to the hospital.
Which is the
Kindly,
police,
my lord.
which is the police station?
Kindly, my
Which
lord.
police station?
Tarabari PS, my lord. Tarabari PS in Borpeta district. Because anything may happen, my lord, his wife in advanced stage.
When the prayer was rejected, earlier prayer,
Earlier prayer was rejected on, my lord, 4/9, very recent month. 4/9, just this month only. Kindly, my lord.
where is the,
Medical is there.
where is the medical certificate?
Yes, that is a page, last page, my lord.
Page number?
Page number 29. These to certify that Mrs. So-and-so had a female who is so-and-so, 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 is about 20 weeks of LPM.
20
Of-
weeks only.
20 months. This is the stage, my lord, with pain and all. If it goes for 4-5 months, then stiffness comes, my lord. Kindly, my lord, kindly. Anything vomiting, whatever.
26 for the case diary. If
Okay,
you
but-
insist, it will go after Puja vacation.
Interim may be given.
No interim.
Because if
How you can claim interim when your earlier
no,
anticipatory bail?
the FIR was filed, they said that on threat or inducement.
Still there is material to show that they filed bail objection.
No, bail
bef-
objection,
be-
there,
be-
my lord.
Before the police station.
Yeah, before the police station.
Stating that you are threatening them. That is enough to reject the bail.
No, my lord, but they have to file here. my lord.
26,
On 20.
26/9.
All right.
May I please do so?
Yes.
Pre bail application, my lord. FIR is page number 16, my lord.
Yes. What is the accusation?
My lord. Page number 16, my lord, FIR is. Reference category PSGD number so and so. Sir, with reference to the subject cited above, I have the honor to report that during preliminary inquiry conducted in connection with the above reference, it is found that a society by the name Unnati Trading Cooperative Society.
What is your name? Jitumani.
My lord?
Norokant.
My lord. My
Who?
name is Norokanto Kolita. I mean, father of the Zitumoni Kolita and mother of the Zitumoni Kolita and brother of the Zitumoni Kolita, my lord.
Okay. Why are you apprehending arrest?
Actually, my lord, my son already been arrested and my name is in the promotion of the society actually. Page number, my lord, 46. Have a look. One of the promoter actually, I also, my 46 number. And police calling me to the police station, my lord, therefore I am apprehending, my lord. My name is
one actually.
Okay,
Is it
and your brother,
Pardon?
father and mother,
My second one is my wife, my lord. I mean Norokanto Kolita's wife. Her name is here
Pranita,
Pronita Kolita, my lord, number 9. I am also
and Kamal Kalita.
Omar Kolita is I am just promoter here, my lord. I am no way actually.
Yes.
connected to- No apprehension regarding that. Actually, Norakanta Kolita maybe the but
Where is the apprehension? Whether police has searched,
calling me and my son already been arrested. If I go there, my lord, if police arrest me, then that is a.
no, where is the apprehension?
Apprehension, there is no.
What
my
is the punishment, maximum punishment?
maximum punishment, my lord, 1 to 5 years with regard to
Whether
the,
notice under 35(3) has been issued to you? Has been issued,
not, my lord, yet to it.
heard, Mr.
CK Medhi, my lord.
G.K. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Noro Kanto Kolita, number 2 Pranita Basho Kolita, and number 3 Kamal Kolita, who are apprehending their arrest in connection with K3PS case number 56/2025 under section 316 within bracket 2/318 within bracket 4 of BNS, read with section 21(1)/21(2)/21(3) of Banning of Unregulated Deposit Schemes Act 2019. The gist of accusation in this case is that on 23/6/2025, one Bhaskar Bora had lodged an FIR before the officer in charge of K3 police station, inter alia, alleging that one society by the name and style of Unnati Trading Cooperative Society Limited was found involved in collecting huge amount of funds from publics in violation of the provisions of Assam Cooperative Societies Act, as well as in violation of the provisions of Banning of Unregulated Deposit Schemes Act 2019. Learned counsel for the petitioner has submitted that the petitioners are not named in the FIR, and the named accused, namely Jitumani Kalita, is the son of the petitioner number 1 and 2 and brother of the petitioner number 3. He submits that the named accused Jitumani Kalita has already been arrested, and as the name of the present petitioners are shown as promoters of Unnati Trading Cooperative Society Limited, the police is asking the petitioners to come to the police station in connection with the aforesaid case without issuing them a notice under section 35(3) of the BNSS. And therefore, they apprehend that if they approach the police, they may be arrested. Learned counsel for the petitioner further submits that the petitioners are ready to cooperate in the investigation. Case diary would be required. Or
Yes, there will be regard, otherwise, involvement may be.
on the other hand, learned additional public prosecutor has prayed for calling of the case diary. Let the case diary be called for
29th of October,
29th.
But-
No. Okay, suggested it. 4th November. Let this case be listed on 4th of November. In the meanwhile, considering the submissions made by learned counsel for the petitioners, As discussed in the foregoing paragraphs, the above named petitioners are directed to appear before the investigating officer of K3PS case number 56/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2, list according.
Must.
Yeah, please, my lord. My lord, this petitioner is, my lord, shocked and surprised, my lord. The notice issue was issued, my lord, under section 35, subsection 3, my lord, of BNSS, my lord. As per case was registered, my lord, to Jorhat police station. Now, my lord, this present petitioner residence Maligaon, my lord. Therefore, page number. Translate copy, page number 9, my lord. With due permission, may I read, my lord?
Yes.
Page 9. With due respect, I beg to inform you that so and so dated at night, so and so I
Okay,
have.
what is your case?
Yes, my lord.
What is your case?
Yes, my lord, regarding theft, my lord.
You go and cooperate with the,
Yes, but yes, my lord, absolute, my lord, correct, my lord. But my lord, interim pair may be.
no, why are you apprehending? 35(3) notice has been issued because police
Yes, my.
do not intend to arrest you.
But as per not naming my, in fact, FIR name. My
When
lord.
is the date fixed?
Date fixed, my lord, already date fixed.
How can be named, my lord, in a theft case, my lord? Someone has, unknown person has missed. Now why he is apprehending?
It is, clearly, but FIR is no mention, this electronic item. What type of electronic items, my lord, theft, my lords? No,
When is
just
the,
only
when
for
is the,
allegation is that electronic
when
items.
is the date fixed?
Date already, my lord, that
Lapsed.
gone, my lord. Yes, my lord, 27/8/2025, my lord.
Okay. Heard Mr. A. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ranjay Kumar Gupta, who is apprehending his arrest in connection with Jorhat PS case number 172/2025 under section 329 within bracket 3/305 within bracket A of BNS. The gist of accusation in this case is that on 5/4/2025, one Rajiv Setia has lodged an FIR that some unknown persons have broken the lock of his office, namely logistic office, and stolen some electronic items. So learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He also submits that the petitioner is a resident of Maligaon in Kamrup Metro District, whereas the offense alleged has been committed in Jorhat. He further submits that the petitioner has received a notice under section 35(3) of the BNSS in connection with the aforesaid case, and the date mentioned in the notice for his appearance, that is 27/8/2025, has already been lapsed, therefore, he apprehends that if now he appears before the investigating officer, he may be arrested. On the other hand, an additional public prosecutor pays for calling of the case diary. Let the case diary be called for. Let this case be listed on 4th of November.
Interim protection may
In the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the date mentioned in the notice under section 35(3) of BNSS has been lapsed, and therefore the apprehension of getting arrested in the aforesaid case of the petitioner is not without any basis. Accordingly, the petitioner is directed to appear before the investigating officer of Jorhat PS case number 172/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like.
First obligation.
Least accordingly. With conditions, two conditions.
May I be the lordship? It's in the POSCO Act, but I have paid for interim on some counts. Page
Where-
14 is the FIR.
Where is the affair?
Page 14.
What is your name?
Accused person 2 and 3 are the petitioners.
Rukia and Abdul.
Yes, madam.
Yes.
The allegation against us is that, my lord, we forced the girl into the vehicle, madam, so that she can elope with accused number 1. Initially, there was no POSCO, my lord. Subsequently, on 20th of August, my lord, section 6 was added, my lord.
But there are allegations against you. Why
Lordship
you
will see, my lord. The date is 11/8/2025, my lord, with the occurrence, my lord, and at around 8:11 AM, the occurrence happened, my lord. Lordship will kindly see that, my lord. Lordship will kindly come to, my lord, page 28, my lord. These are CCTV footage from my shop, my lord, petition number 1, my lord. The lady in the headscarf, my lord, talking to the little girl, my lord, that is me, my lord. That is on 11/8/25 at 10:50 AM.
How far is your shop from the residence? 10 minutes gap.
No, my lord. The girl's house is next, near to the accused number 1's house, my lord. Lordship will then turn the page, my lord. 11:06, my lord. I'm still at my shop, my lord. Then Lordship will be more surprised, my lord. Lordship turn to page 30, my lord. This is the man in front of the white bolero, my lord. That is accused petition number 2, my lord. What does it say? Right. He is at People's Smart 6 mile, my lord. The place of occurrence is at, my lord. What is it? Some village at Larua Jan, my lord. Page 31, my lord, Lordship will see, my lord. Again, that person, my lord, is there, my lord. Page 32 is from the hospital's camera, my lord. Tinita's hospital, my lord. That man in the shirt, my lord, raising his arm, my lord. That is at 11:30, my lord, at 6 mile, my lord. Before lodging of this,
Who is this person?
at page 32, my lord.
32?
The man raising the hand, my lord, he is accused petition number 2.
Abdul Barek.
Yes, my lord.
Okay.
Before lodging of the FIR, my lord, at page 38, my lord, we filed a petition against the informant under section 126, keeping the peace, my lord. Therein, my lord, Lordship will see, my lord.
Page number?
Page 38, it starts, my lord. The petition, my lord. It is 23/7/2025.
126 is corresponding to 107.
Yes, the new one.
Okay.
Page 39, my lord. Para 4, my lord. Lordship will see, my lord.
Yes.
The victim girl and the accused number 1, my lord, they had some relationship or whatever it be, my lord. They had eloped earlier on several occasions. The family members said that when you reach the age of maturity, let them be married. But then the incident happened, my lord. Para 5, Lordship will see, my lord.
Okay. Yes, Mr. Parashar.
Otherwise, though men
accused is not there, but there is the forcefully in the car.
Yes,
That is,
but his case is that he was not there. Case diary would reveal.
This footage may be analyzed by the IO, I mean,
Heard Mr. N. Mahajan, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Rukia Khatun and number 2 Abdul Barik, alias Abdul Barik, who are apprehending their arrest in connection with Goroimari PS case number 71/2025 under section 87/3 within bracket 5 of BNS, read with section 6 of the POCSO Act. The gist of accusation in this case is that on 11/8/2025, the father of the victim girl, no, the maternal uncle of the victim girl had lodged an FIR before the officer in charge of Goroimari police station, naming therein 4 accused persons, including the present petitioners, inter alia alleging that on that day at around 11 a.m., the accused persons named in the FIR forcefully kidnapped her from her residence and confined her in the residence of accused number 1. What has happened to accused number 1?
He has been arrested. His foreign report is at page number.
Learned counsel for the petitioner has submitted that the accused number 1 named in the FIR was in a relationship with the victim girl. And who is accused number 1? How he is related to you?
Accused number 1, petition number 2, he has a school. Accused number 1 and 2, the accused number 1 and the victim girl, they study in that school.
He further submits that no accusation under POCSO Act has been made against the present petitioner. He further submits that prior to lodging of the FIR on 11/8/2025, the petitioner number 2 had lodged an application before the district magistrate Kamrup Amingao for initiation of a proceeding under section 126 of BNSS against amongst other against the informant of the FIR.
Informant is the opposite party number 1.
He further submits that the alleged incident, he further submits that both the petitioners were not present at the place of alleged occurrence of offense. And to substantiate his submission, learned counsel for the petitioner has produced the screenshots of CCTV footage and annex the same as Annexure E series. Annexure E series in the bail application, which shows that on that day, at the relevant point of time, the petitioner number 1 was in whose shop is this?
That is her shop,
In her shop situated at Where? Situated at, where is the shop?
At her village, madam. This one. Ladwa Janman.
Huh?
Ladwa Janman.
I-
Petition number 1.
Shop at
Ladwa
Larva John. Whereas the petitioner number 2 was present at
People Smart Mallet, 6 mile.
at where?
People Smart Mallet, 6 mile Guwahati.
People Smarts,
And then he went to Mallet Trinitas Hospital.
6 mile, and thereafter he went to Trinitas Hospital, which is away from the place of occurrence of offense. The petitioners, learned counsel for the petitioners has submitted that the main accused has been arrested in the meanwhile, and the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Let the case diary be called for. Victim has been recovered.
Yes, Mallet, page 26.
Let the case,
Recovered from accused number 1.
he also submits, he also submits that in the meanwhile, victim has been recovered from the
Accused number 1.
accused number 1.
Final
Stop. Let the case diary be called for November. Let this case be listed on 6th of November. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, as well as considering the annexation documents annexed along with the bail application, both the petitioners are directed to appear before the investigating officer of Saigon PS case number, Goromari PS case number 71/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount. Interim bail of rupees 30,000 each with one surety of like amount, subject to satisfaction of the arresting authority with following conditions. 1, 2, list accordingly.
Notice 1.
Oh, yes. Later, before this relief, let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, in pursuant to the prevailing notification of the registry in this regard, returnable on 6th of November.
Obliged, highly requested.
May it please your lordship. This revision petition is against the final order given by family court lordship in a maintenance proceeding lordship. MP order is at page 39 lordship. This maintenance is not between husband and wife lordship. It is against the father directing him to pay maintenance to the minor child lordship filed by the wife lordship.
Daughter,
Yes, lordship, daughter,
how much?
4,000 lordship. And in this
We are
case,
issuing notice.
lordship, may I pray to remand this matter as because though it is not in between the husband and wife, there is a clear direction by the Supreme Court in maintenance cases, Rajneesh versus lordship Neha. Lordship, assets and liabilities to be submitted by both the parties. In this case.
No, but let us hear the
Lordship.
other side.
Lordship. Another case by this court lordship, where at the motion stage, it was remanded back to comply with the Rajneesh lordship. This is a mandatory provision lordship in Rajneesh. paragraph 65, it is stated that this court lordship in similar situation, lordship, it was remanded back for fresh trial after the
No, not now. After service of notice. Heard Miss R. Chaudhary, learned counsel for the petitioner. Also heard, no,
I'm for a small one on the.
also heard, state has been made party.
this lordship.
Also heard Mr. K. Parashar appearing for respondent number 1. This application under section 438/442 of BNSS has been filed by the petitioner, namely Nazir Hussain Chaudhary, impugning the judgment and order dated 19/5 2025 passed by learned Principal Judge Family Court in FC within bracket criminal case, Principal Judge Family Court Kachar in FC within bracket criminal case number 28/2022, whereby the petitioner was directed to pay a maintenance allowance of rupees 4,000 to the daughter of the respondent. The petitioner is seeking interference of this court mainly on the ground that the guidelines of Apex Court issued in the case of Rajneesh versus Neha reported in
2021 SCC, page 324, lordship.
Likha has not been followed in this case. Issue notice to the respondent. Number 2, the petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. No, only 4,000. You pay till for 1 month.
6,000 per month. So can it be 50% of that amount?
No.
lordship?
No
Will it be-
interference now. Only after appearance of the
That may kindly be recorded, that interim prayer may be
The
considered.
prayer for interim relief would be considered only after due service of notice on the respondent number 2.
of less.
This is a revision by the department against we have challenged the validity of order dated 24/8/2025 annexure I, page 35. But see what happened in this case? The case was registered in Guwahati and the accused was residing in Tinsukia. He was arrested there. Thereafter, we filed an application for transit remand.
Where is the impugn order?
Page 35.
Yes,
Merit law.
yes. No,
Yes.
what it says impugn
It
order?
says the proceeding filed an application for transit remand, seeking transit for 48 hours to produce him before the court of competent jurisdiction. The learned trial court granted bail and rejected our prayer.
Okay,
So under the law, lordship, the court at Tinsukia has no jurisdiction to entertain the bail application. Essentially, this is our ground.
okay,
will
we'll
challenge-
issue notice.
Yes.
Heard Mr. SCKR, Learned Standing Council, DGGI. DGGI.
Lordship.
This application under section 438/442 of BNSS has been filed by the petitioner impugning the order dated 24/8/2025 passed by learned Judicial Magistrate First Class Tinsukia in connection with case number DGGI/INV/FUP/168/2025, whereby the respondent was granted bail by the said court. Issue notice to the respondent and call for the records of
So probably Consular Court has transmitted the record to Guwahati Court. Otherwise, we have annexed all the documents.
Okay, we will not, we are not calling. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
That's it.
So the petition authority or lordship has SLA order, and before going to that lordship, I will just like to point out the factual matrix lordship. The wife of the petitioner has preferred a petition for 125, seeking maintenance from the husband, and the landed principal of family court was pleased to grant maintenance of rupees 3,000 per month. I judgment ordered at 30/10/2012. Thereafter, lordship, she has preferred an application under section 127, seeking enhancement to rupees 8,000. And in that case, the learned trial court was pleased to enhance the amount to rupees 5,000. Against that order, lordship, the petitioner on earlier occasion has approached this honorable court, and this honorable court was pleased to pass an order by reducing the enhanced amount to rupees 4,000. Lordship will find the order at page 30, Annexure C.
Okay.
Yes, lordship.
Page,
Page 30, lordship. Operative part is at page 32, lordship.
okay,
Have lordship got it?
okay. Thereafter, what happened?
Yes, lordship. Here, this honorable court has pleased to reduce the amount to rupees 4,000. Thereafter, lordship ordered it at 25/2/2019, lordship. Then again, in the month of November 2021, the wife again sought an application for under 127 for enhancement of the amount, whereby lordship will find the application, lordship, at page 33. It starts at page 33, lordship, whereby she has stated that the learned principal of family court has enhanced the amount to 5,000, and nowhere in her petition as well as in her evidence she have disclosed that this honorable court has reduced the amount to 4,000.
Thereafter,
lordship, the impugn order was passed. Lordship will find the impugn order at page 49A. Have lordship got it?
yes.
Lordship, may I read the order?
Now, what was
Yes,
directed?
and is in this order, lordship, at page 52, the learned trial court has granted, directed the husband to pay an maintenance amount of rupees 12,000 to the respondent and her child.
When this order was passed?
This order was passed on 21/5/2025. Lordship will find at page 50, the date of the judgment.
And the High Court
Sorry, lordship.
reduced the order in
In the year on
19.
Yes, 25/2/2019, and the petition was filed on 13 November 2021. Lordship will find at page 36.
But there is a gap of time.
Yes, no, I am not against the enhancement, lordship, but I am against that the material things has been suppressed while
Okay,
preparing the
now what is a prayer?
enhancement. Thereafter, for a formal selection, lordship, mindly peruse page 55 for a moment, lordship. Annexure I. It is certificate issued by the employer of the petitioner, lordship, whereby he is getting a salary of rupees 10,500. Because he is just a manager of the Bajaj dealer situated at Satibari Road, lordship. So and in the last page,
You contested that 127 application.
I preferred my written statement, but subsequently I could not appear because of my ailment. I have annexed my medical documents also because I am a cardiac patient. Because I have to go cardiac, so I could not contest the case in the later part.
And Lordship, the,
That was your fault.
yeah, that was admittedly my fault, but Lordship, the order, while passing the order, Lordship, as per Rajna versus Neha, Lordship, it is categorically stated, may I read the, for a moment, Lordship, for a second, at page 369.
What?
Sorry.
What has been stated?
Yes, Lordship. In paragraph 72.1, the affidavit of at page 369, Lordship.
Yes,
Have Lordship got it?
yes.
At 72.1, Lordship, the affidavit of disposal of asset liabilities annexed at annexure and enclosure 1, 2, and 3 of this judgment, as may be applicable, shall be filed by the parties in all maintenance proceedings, including pending proceedings before the family court, district court, magistrate court concerned, as the case may be throughout the country. And this judgment was not complied, Lordship.
Now, how much you can pay?
Lordship, I will pay Lordship for 5,000. Till at this stage, my limited probability that notice may be issued, Lordship, and I will be directed to pay 5,000 for the time being, Lordship. Let them appear.
Heard Mr. S.N. Krishnatreya, learned counsel for the petitioner. Also heard Miss, no. This application under section 19 within bracket 4 of the Family Courts Act 1984 has been filed by the petitioner impugning the judgment and order dated 21/5/2025 passed by London Principal Judge Family Court, Kamrup Metro in Miss case number 521/2021 in connection with FC within bracket criminal case number 350/380/2008, whereby the petitioner was directed to pay enhanced monthly maintenance allowance of 7,000 to the respondent number,
Respondent, Lordship.
to the respondent, and rupees 5,000 to his daughter, within bracket total of rupees 12,000. Learned counsel for the petitioner has submitted that before approaching the family court by filing the application under section 127 of the Code of Criminal Procedure, in which the impugn order has been passed. On an earlier occasion also, the respondent had filed an application for enhancement of monthly maintenance allowance payable by the petitioner. Stop. Learned counsel for the petitioner submits that originally by order dated 30/10/2012 passed in
First in Lordship, FC criminal case number 350/2008.
the petitioner was directed to pay a monthly maintenance allowance of rupees 3,000, which was enhanced by the trial court on filing of an application by the respondent under section 127 CRPC to rupees 8,000,
5,000, enhanced to rupees 5,000.
enhanced to what was the total enhancement in which was later on?
Earlier 5,000, reduced to 4,000, then again enhanced to 12,000.
Which was enhanced to 5,000, against which the petitioner had preferred a
Page 30, Lordship.
preferred an criminal revision petition, that is criminal revision petition, which was registered as criminal revision petition number 276/2016, which was stopped. The said criminal revision petition was disposed of by a coordinate bench of this court on 25/2/2019, whereby this court reduced the enhanced amount to rupees 4,000 per month. Stop. Learned counsel for the petitioner submits that thereafter the respondent has again approached the family court, approached the principal judge family court by filing an application under section 127 CRPC seeking an enhancement of the monthly maintenance allowance. Learned counsel for the petitioner has submitted that in her petition under section 127 of the CRPC, the respondent had suppressed the fact that a coordinate bench of this court by order dated 25/2/2019 has reduced the amount of monthly maintenance from rupees 5,000 to rupees 4,000 per month. Learned counsel for the petitioner has further submitted that the petitioner, where is the certificate?
Salary certificate, sir.
The petitioner
Page
is
55.
currently posted as spare part manager. Spare part manager gets only 10,000.
Yes, Lord, because Lordship, it is a mere outlet, Lordship.
Spare part manager and drawing a salary of rupees 10,000 per month since the month of April 2025. And to this effect, a salary certificate has been annexed along with this revision petition as annexure 1. Learned counsel for the petitioner has further submits that there has been a violation of guideline of the apex court in the case of the guidelines issued by the apex court in the case of Rajneesh versus Neha, reported in 2000 and what is the citation?
2021, 2 SCC 324.
2021 3 SCC 324. In as much as no affidavit of assets and liabilities were submitted by the respondent before the learned principal judge family court. Under such circumstances, the petitioner has, learned counsel for the petitioner has prayed for interfering with the impugned order. However, learned counsel for the petitioner also submits that the petitioner is ready to pay an amount of rupees 5,000 per month to the respondent. Stop. Considering the submissions made by learned counsel for the petitioner, as well as considering the materials available on record, let the notice be issued to let the notice be issued or let it be in the earlier paragraph. Let the notice be issued to the respondent. The petitioner shall take steps for issuance of notice upon respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on, give a fixed date, November, on 10/11.
It not be on 10/11, my son's first birthday. After
12th of 11, 12th of November. In the meanwhile, considering the submissions made by learned counsel for the petitioner, the as well as also considering the materials available on record, the impugn order is the execution of impugn order is stayed till next returnable date, subject to condition that the petitioner shall continue to pay an amount of rupees 5,000 per month to the respondent.
In page 54, in criminal number, case criminal execution case number 403/2015.
In criminal execution case number
403 of the
403/2015. List accordingly.
deeply obliged.
May it please your lordship. That's a petition under section 36A4 of the NDPS Act, my lord, filed by the prosecution was allowed, my lord. The petition was filed by the investigating officer. No right of hearing was given to the my lord, accused, my lord. On that.
What
count,
is 36A4?
my lord, where extension of period, investigation period is my lord, extended, my lord, to from.
Okay,
180
180 to
Yes. The petition is at page 42. Commercial quantity and was seized, my lord, of goods was FIR lordship can see at page number.
Where is the impugn order?
That the impugn order is at page 34, my lord.
Impugn order dated.
14/8/2025, my lord.
What is your ground?
There are two grounds only. One, the investigating officer cannot file such petition, but it has to be filed by the public prosecutor. Two, right of hearing must be given to us, my lord. That these are only two grounds, my lord, and subtle principle of law, my lord. Lordship may kindly see the impugn order, page 34, clarifies all the aspects, my lord. Case record is put up today on the basis of a petition dated 13/8/2025 filed by the IO on being endorsed by the learned PP seeking extension of the period of investigation and custody of the accused Ajay Bora and Purit Bora.
Filed by
till
IO by
such
endorsing by
ex-
the IO.
You will have your chance, my friend.
No, that's only.
Filed by the filed by where I was not till such in
NDPS.
term. I read start from the beginning. Lord. Case record is put up today on the basis of a petition dated Etna filed by the IO on being endorsed by the learned PP seeking extension of the period of investigation and the custody of accused Ajay Bora and Purit Bora till such extended period in terms of the provision laid down under section 36A4 of the NDPS Act 1885 for enabling him to file the report in final form in case. It appears from the record that the accused Ajay Bora and Purit Bhutan have already completed 171 days and 165 days respectively in judicial custody since their arrest on 23/2/2025 and 11/3/2025. Third, learned PP as well as IO also perused the petition filed by the IO as well as the material available in the case record and the case diary. It appears that the IO has prayed for extension of the custody for accused Ajay Bora and Purit Bhutan on the following grounds. So the grounds are, dear lordship, that FSL report was not made available to them, lord. They were skipping that, the primary reason ground for seeking extension of the period of investigation basically seemed to be that the FSL report of the seized contraband substance yet to be made available to the investigating agency. The IO is also apprehensive of the disappearance of the accused once they are released on bail. In this case, accused Ajay Bora and Purit Bora so and so have completed 171 days and 165 days respectively in judicial custody as on today. Accordingly, consider the aforesaid facts and circumstances. The prayer made by the IO is allowed. The IO is granted a period of another 90 days to complete the investigation into the case and the detention of the period of accused Ajay Bora and Purit Bora
Records
accordingly
would be
extended.
necessary because 36A4 says that a report of PP, whether report, it may be filed by anyone, but report has to be there.
But he cannot just simply endorse the petition without. And
Whether that can be regarded as a report.
no, without. There is a settled position of law. One judgment of the Guwahati High Court is also there. We have furnished the copy.
We will call for the records.
Lordship, in this case, the order is sacrosanct, my lord. The order speaks about everything, my lord. The case can be disposed of. It cannot be, because I am already in custody because of this order, my lord. So there is judgment of the Guwahati High Court. But excuse me, we have furnished the copy to the bench. What is it? Judgment of copy. The Guwahati, the Supreme Court and Guwahati High Court judgment also, my lord, page 7, my lord, page 4, paragraph 7 it starts from, my lord.
No, but we don't know whether the report was there or not.
My lord, it's still there in the report, order of the London special judge, my lord, and order cannot be changed, my lord. Sacrosanct, my lord. Page 7, my lord. He has quoted the Supreme Court, my lord, page 4, paragraph 7, lordship has, my lord.
Yes.
Paragraph 7, a public prosecutor, I'm just reading the quoted portion, my lord, 2005, my lord. A public prosecutor is an important officer of the state government and is appointed by the state under the Code of Criminal Procedure. He is not a part of the investigating agency. He is an independent statutory authority. The public prosecutor is accepted to independently apply his mind at the request of the investigating agency before submitting a report to the court for extension of time with a view to enable the investigating agency to complete the investigation. He is not merely a post office or a forwarding agency. A public prosecutor may not agree with the reason given by the investigating officer for seeking extension of time and may find that the investigation had not progressed in the proper manner or that there has been unnecessary, deliberate or avoidable delay in completing the investigation. In that event, he may not submit any report to the court under clause BB seeking extension of time. Thus, for seeking the extension, this was under quota. Same principle applied. This has also been held. Thus, for seeking extension of time under clause BB, the public prosecutor, after independent application of mind to the request of the investigating agency, is required to make a report to the designated court, indicating therein the progress of the investigation and disclosing.
Where is the application?
Lordship.
You have annexed the copy of application.
Yes, that is at page 32, my lord. We start with page 32 and lordship can see page 33. Your faithfully so and so, Belcher PS, PP. And that has been endorsed, my lord, forwarded by the, and no right of hearing was provided. So on both the ground, this order cannot stand. My lord. Page 32, it starts with page 32, my lord. Forwarded, attested public prosecutor, Naga. And
Page
32, lordship.
30?
Last in the
Okay, only this endorsement is
this
there.
endorsement is there. The order cannot stand, my lord. And I am in custody for more than 200 days as on date, my lord.
Yes, Mr.
That filed by IO, ground is given that official
No,
notice submitted
the
and
requirement is, it may be filed by anybody, a report
report
has to be there from the public prosecutor.
report. Last grounds, it is mentioned as a ground that official is not given, that is given and filed by, but the second ground is opportunity, that is true, that has to be given. That is true. And in a production date, if in presence of the accused, if that is passed, then but it seems that accused is not present.
Heard. Mr. A. Lal, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 438/442 read with section 528 of BNSS has been filed by the petitioner, namely Ajay Bora, impugning the order dated 14/8/2025 passed by learned Special Judge Nagaon in what was the NDPS case number?
NDPS case number.
In Nagaon PS case number 152/2025, whereby under section 36 within bracket 36A within bracket 4 of the NDPS Act, the period of detention of period of detention of the present petitioner was extended beyond 180 days for how many days it was?
90 days. my lord, yes, in the
For more, 90 days more. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since last how many days?
My lord, 206 days, isn't it, my lord?
206 days in connection with the aforesaid case, which was registered under section. What is the penal section?
That's it.
Penal sections?
Section, my lord. Section 22C, my lord. Of-
Twen-
And section 25. of the NDPS.
22C/25 of the NDPS Act. He submits that the trial court has erred in allowing the petition filed by the investigating officer without there being any report of the public prosecutor indicating the progress of investigation and the specific reasons for detention of the accused petitioner beyond the said period of 180 days. He submits that in the instant case, the petition for extension of time was filed by the investigating officer namely Bhardwaj Chetri on 13/8/2025, and same was merely forwarded by the learned public prosecutor Assam and public prosecutor Nagaon, which is not in consonance with the statutory provisions contained in section 36A within bracket 4 of the NDPS Act. If in support of his submission, he has cited a ruling of the apex court, no, ruling of this court in the case, ruling of a coordinate bench of this court in the case of Jayanandan Prasad and another versus State of Assam, reported in 2012, 3 JLR 397, wherein quoting the observation made by the apex court in the case of Hitendra Vishnu Thakur versus State of Maharashtra, reported in 2001, 5 SCC 458. It was observed as follows. Quote para 7 from the said judgment.
7, 8, and 9. lord.
No, only 7.
But-
Only 7 from this judgment. Learned counsel for the petitioner has further submitted that the petition was moved, the petition for extension of the period of detention was filed by the investigating officer on 13/8/2025, which was not a fixed date of that case. And the impugn order was passed without hearing the petitioner and without giving any opportunity to the petitioner of, no, without giving any opportunity to the petitioner of being heard. Stop. He therefore submits that the impugn order for the aforesaid reasons is bad in law and liable to be set aside. Stop. Learned additional public prosecutor, on the other hand, submits that the the application for extension of period of detention does contain the specific reasons for which the extension of detention beyond the period of 180 days was sought for. However, he fairly submits that no, the said application was has only been endorsed by the public prosecutor without there being a separate report as required under section 36A within bracket 4 of the NDPS Act. He also submits that he also fairly submits that the impugn order indicates that no opportunity of being heard was afforded to the petitioner while passing the extension order. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. As held by the apex court in the case of San Hitendra Vishnu Thakur versus State of Maharashtra Supra, a public prosecutor is expected to independently apply his mind to the request of investigating officer agency before submitting a report to the court for extension of time with a view to enable the investigating agency to complete the investigation. He is not supposed to act as a mere post office or a forwarding agency. However, in the instant case, exactly that has been done. The public prosecutor has merely forwarded the application to the special court of learned special judge without filing any separate report after applying his mind. And therefore, on that count itself, the impugn order is liable to be set aside. Moreover, it also appears that no opportunity was afforded, no opportunity of being heard was afforded to the petitioner before passing the impugn order, which is also not in accordance with the principles of natural justice. Stop. For aforesaid reasons, this court is of considered opinion that the impugn order is liable to be set aside, which this court accordingly does. The order dated 14/8/2025 passed by the Court of Learned Special Judge Nagaon, Assam in Nagaon PS case number 152/2025 is accordingly set aside. This criminal revision petition is accordingly disposed of.
Thank you.
May I
Yes.
tell you? Here in this case, my lord,
initially 7,000 Miller. And by order dated 27/8/2025, enhanced to 24,000 Miller. 7,000 to 24,000.
When was 7,000? What is the date?
Miller.
What was the date of the original order?
1/9/2018 Miller. And petitioner receiving salary Miller as per her statement in paragraph 39. She has stated 44,500, 400 Miller, page 32. And as per Honorable Supreme Court Miller, 25% net salary would be adjust Miller as a award to the wife Miller, wife and child Miller. In this case, Kalyan Rai Chaudhary versus Union of the Rita De Chaudhary.
When is the impugned order has been passed?
Impugned order case is 27/8/2015 Miller, case 40. And relevant part is case 46.
What is your salary?
At present Miller, my salary is Miller net salary is pays 48.
What is the gross salary?
Net gross salary Miller 60,000 and net salary 54,994. Page 48. A net amount 54,994 rupees per month. And petitioner is Miller, he has some liabilities Miller, he has to pay a loan amount.
Whether any child is there?
Yes, Miller.
How many?
1 Miller. One child and wife Miller. And subsequently he has got married and he has got also one child Miller. I am not disputing the Miller enhancement matter. 2 marks is 2 marks Miller. 7 to 24,000. And 25%.
What is the date of impugned order or recently?
27/8 Miller.
We are issuing notice.
Miller, in the meantime, Miller, I am not disputing Miller. I am paying Miller at least 25% of my salary Miller.
No.
25% is 14,000.
Heard Mr. A.M. Ahmed Learned Counsel for the petitioner. Also heard no. This application under section 438/442 of BNSS has been filed by the petitioner, namely Safiqul Islam. What do you do?
Miller, I am paying 13,700, 14,000.
No, what do you do?
My constable Miller, APBN. 8 Assam Battalion constable. 54,900 salary. I can provide Miller 25%.
Impugning the order dated 27/8/2025 passed by Learned Principal Judge Family Court Barpeta in FC criminal case number Miss Case number 571/2022 under section 127 of CRPC, whereby the maintenance allowance to the respondent was enhanced to rupees 12,000 per month, as well as to the minor daughter of the respondent number 1 to 12,000 per month from 1st of November 2025, within bracket total 24,000. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon respondent by registered post with ID, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
In the meantime, I may be allowed to pay 14,000.
No.
I ask for Supreme Court judgment.
No, we will examine that. We will examine that. Let the other side appear.
I have judgment. At least me 24,000 is too much. 54,000 salary. A petitioner got
No,
one
no interference now.
salary.
Let the other side appear.
There are 14,000 at least.
She is your wife and your
Yes, my lord.
daughter.
I am not a disagreeing with her. I am not disagreeing with her. I am
Then,
paying
then
with her.
you can pay at least for 1 month till her appearance.
Yes, my lord. That part maybe I have.
No. Yes,
That
next,
part maybe I
next
have.
time.
My lord. This month I will pay that to 24,000. Next month, from the next month, my
The
lord, I-
prayer for interim relief sought for by the petitioner would be considered only after due service of notice on the respondent. None has appeared. None has appeared for the petitioner on call. It appears that name of the counsel for the applicant has not been shown in the cause list. The registry is directed to reflect the name of Mr. P. Bordoloi and Ms. N. Nirola as engaged counsel for the applicant in the cause list henceforth, and list this matter again on a date to be fixed by it.
22.
So it is an application of 428 BNSS. But I take to law, if the FIR is in page number 40, for in minute 1 person, driver Rajibul Islam was arrested on 5/5/24. Subsequently, case was charge sheeted and he was enlarged on bail by the court, landed court below on the ground the violation of fundamental right, that is not following 47/48 of the BNSS. My lord, thereafter, my lord, case was charge sheeted on 4/1/25, 31/10/24, and charge was framed on 4/1/25 against the known accused, my lord. But notice was issued, it was fixed for 13/25 for evidence, but landed court below has issued notice on, my lord,
What notice?
to me, my lord, to me and to others, for summons. But summons, we have not appeared on the same day, my lord. He issued non-bailable warrant of arrest, my lord, against us. Then, my lord, thereafter, my lord, court came to complaint, notice was served, PNA was issued, and ultimately, my lord, case was separated from, that is, my case has been splitted up. That's why I have, that is the page 45 is the order, my lord. Upon considering the above, the court is also deem it fit to split up the case against the said accused person, Rajibur Haq, Lashkar, Julu. I am for Julu Haq, Lashkar, my lord. There are 3 other persons, and in the charge sheet, my lord, our name has been reflected, but no reason has been given why and how, for what connection our name has been reflected here. That's why we want to participate in the trial, my lord. That's why we have come that they read all the number warrant of arrest.
You are earlier granted bail.
No, I was not, never. I never appeared also. Because I mean, nobody was called. But someone was sent to me. And
You
court
received
said
the
that-
summons.
court
you
said
received it.
that someone was served upon me. So,
And what
I
do
must-
you say? What do you say? Summons were received.
was served, definitely. Otherwise, why problem? That, but court has issued, the same day, I did not appear. So, non-bailable warrant was issued against me, my lord. And ultimately, there are PNA, and thereafter, my lord, split up the case, my lord. Now, my lord, I have come before your lordship with a folded palm that I want to face the trial instead of this such type of harassment and non-bailable warrant. If I have taken into custody, I'll never granted bail. My bona fide is that I want to face the trial because I am innocent, nothing was recovered, and moreover, my 21C will not be applicable to me, subject to the correction, my lord, to my knowledge.
21C is there.
Yes, 21C against the main accused person, that is Rajibul Islam Roscoe driver, my lord, who carried the contrabands of heroin, my lord, 3,102 grams heroin. It was found from his position.
Yes,
If they want to appear, they can appear, but
Okay.
nothing other than that.
okay. Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Julu Haq Loskar, alias Rizbul Haq Loskar, impugning the order dated
21 to 25 minutes first.
order dated. You are impugning mainly this 21 to,
25 minutes.
where is that order? Page, page number,
21 to 31 minutes.
where is that order? In which,
31 page. Issued on bill warrant. Annexure 4.
impugning the order dated 21 to 2025 and subsequent orders passed in NDPS case number 119/2024 passed by learned additional sessions judge Kachar, signature, whereby the trial court had issued non-bailable warrant of arrest
Along with PNA, page
against
32.
against the petitioner. Learned counsel for the petitioner has submitted that later on the
Page
orders
45.
orders for proclaiming the petitioner as absconder and attachment of his properties were also issued. And a standing warrant of arrest was also issued. He further submits that by order dated 11/6/2025, the case of the petitioner was split up from the case of other co-accused persons who were appearing before the, who was appearing before the trial court. Learned counsel for the petitioner has submitted that the petitioner's name has been shown in the charge sheet as an accused without,
Absconder.
as an accused who is as an absconding accused. He also submits that no incriminating material has
Was
been,
reflected in charge.
was reflected in the charge sheet against the present petitioner. He also submits that the present petitioner is ready to face the trial. However, as a non-bailable warrant of arrest has already been issued and same is pending, he needs some protection so that he may appear before the trial court. Learned, on the other hand, learned counsel for the learned additional public prosecutor has submitted that if the petitioner intends to cooperate in the investigation, in the trial, he does not have any objection. to say.
By order to that 11/6/25, he has already been declared as proclaimed offender.
That I have submitted for PNA.
That I have reflected.
DNA is different.
Oh, yes.
He has been declared proclaimed offender.
He however submits that by order dated 11/6/2025, the trial court has already declared the petitioner as an proclaimed offender. Stop. I have considered the submissions made by learned counsel for both sides. Though the petitioner has been declared as an proclaimed offender by the trial court, however, as the petitioner is ready and willing to face trial, When is the next date fixed? What is the next date?
My lord, last date was 30th of August, but thereafter I did not.
This criminal
15th,
petition,
15th days.
this criminal petition is disposed of with a direction to the petitioner to appear before the trial court,
Additional session, just yes.
trial court in NDPS case number 119
Special judgment.
2024 within a period of 15 days from the date of this order and cooperate in trial. To facilitate his appearance before the said court, the operation of pending non-bailable warrant of arrest issued against him shall be stayed for next 15 days.
But thereafter I will pay for regular bail, which may be considered according to law.
On his appearance before the trial court, he may
File
He
for
may-
regular bail prayer.
he may pray for any relief to which he is legally entitled to.
Yes.
I just add lordship, the petitioner lordship, we have a pending AB pending before this court in principle.
Okay, that would become infructuous,
That will become infructuous.
but that you have to inform this court.
Yes, sir, this is.
That in that case, you lordship has call for the scan copy.
Whether that has been mentioned.
But
the
in,
present petition.
in this case, you
I'll appear.
no, that is not the question. In this case, have you mentioned about the pending AB?
Probably have not mentioned.
That would amount to suppression of fact. Then you are,
Counsel is also same lordship. Counsel is also same lordship in both the cases.
Let both the cases come together then.
no, we are disposing of.
All right. I will do that one.
I would not suggest anything.
Anyway, I will do. Thank you.
Last line to continue. Okay. Rako.
23.
Yes, please.
It is a lordship. Here we are agreed. By order dated 18/7/25, which is at page 33, my lord, whereby the Jimma pair of the petitioner was rejected. What happened in this case, my lord, the offense registered under 21B, and accordingly, my lord, charge sheet was filed. Page 19 is the charge sheet. And thereafter, lordship will kindly peruse my lord, page 23, column 19. In the charge sheet, it was stated by the prosecuting agency that vehicle was processed for freezing, my lord.
Page,
Page 23, column 19, serial number 19, madam. Number of, as an sir, lordship has fine, madam.
what is there in serial number 19?
18 dispatched number, lordship is perusing page 23, madam.
Yes,
Yes, dispatched number, we do not know, madam, what is that? 19, number of enclosure lordship has got, madam. It says one FSL report and 2 is the freezing process documents. So
yes.
they said that, madam, the vehicle was under the process of freezing, madam.
Vehicle cannot be freezed.
Process. Under 68, madam, it can confiscation.
Confiscated. It
Confiscation.
may be
Yes,
confiscated.
madam. That was perhaps the prosecuting agency was to address this issue like confiscation, madam, but it was written as freezing process, madam. So, madam, thereafter, madam, I approached the trial court again, madam, for release of my vehicle. Then, madam, the London trial court called 2 reports. That is, madam, one is at page 31, annexer 8, 19/5/25. Report was called for, madam. May I just read, madam, that report? 31 lordship has got, madam.
Yes.
Yes. With reference to the subject cited above, I have the honor to report that as your honorable court sought for the Jimma report of the seized vehicle Maruti Express Smart Hybrid so-and-so, which was seized by DEMA number so-and-so by the IO of the case in connection with the so-and-so reference. Moreover, the case has already been charged sheet by White Bongaigaon PS case number so-and-so, whereas the IO of the case has already submit one requisition to the authority to confiscate the seized vehicle mentioned above, but the report from the authority is yet to be received, whether it has approved or not. So that was the report, my lord, with regard to the vehicle, my lord. Till, my lord, after 2 years also, no confiscation confirmation report was received by the IO, my lord. Again, so my lord, the learned trial court, again, my lord, called for a report on page 35, my lord. That is the last report which was received by the court, my lord. There also, my lord, they intimated the learned trial court that authority may just read, my lord, the last paragraph.
Yes.
Therefore, the previous IO sent a requisition to the concerned authority for confiscating the seized vehicle, but the report from the concerned authority is yet to be received, for which the seized vehicle cannot be left in Jimma. And based on that report, my lord, the impugn order was passed, which is a page 33 type copy, my lord. So my humble submission is that, my lord, on the curve of this, my lord, report, my Jimma cannot be, my lord, rejected, because my vehicle is my lord, left.
You are an accused in this case.
Yes, my lord. And the owner of the case and the owner of the vehicle, my lord.
Then if he,
If the vehicle is purchased from the money of
no, otherwise, if the vehicle is used
yes, that
for the
means-
commission of
yes,
the
sir.
offense within the knowledge of the owner, then whether he is entitled to get.
Vishwajit, the case was, my lord, there was no bar, my lord, in this case.
No
Read the
bar, but
judgment, my lord.
it can
No
be,
bar was put by the Honorable Apex Court, my lord, that Jimma cannot be granted, because there is no such specific bar either in the NDPS, my lord, Act or in the CRPC, my lord.
bar is not there, but any movable, immovable property, which is purchase or
We will examine.
so he has to examine.
We-
Of confiscating also, my lord, the investigating officer has to come to an opinion that the vehicle was purchased with the money, my lord.
No, vehicle has been used with the knowledge of the,
Yes,
Yes, sir.
even if it is not purchased, if it is used
Used
with the
in the-
knowledge of the owner, then it is liable to be confiscated.
for confiscation, my lord, notice is also necessary in Vishwajit J case also, my lord, the Honorable Apex Court say. But in 2 years, my lord, I have not received a single notice or any confirmation order, my lord, that my vehicle has been processed or any proceeding has been initiated, my lord.
What was the report, last report dated?
Last report is, my lord, dated, my lord, it is reference number so and so dated 3/6/25. 3/6/25.
3/6 or 19, Right.
Lordship is having, my lord, page 35, my lord.
35 is 3/6.
Yes. 35 is, my lord. 35 is the report, my lord, and 36 is the order, man, whereby prayer was rejected.
Okay, we are issuing notice. Calling for the scanned copy of the case diary.
Yes, sir.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS, read with article 227 of the Constitution of India, has been filed by the petitioner Amar Farooq Hussain, impugning the order dated 18/7/2025, passed by the Court of Learned Special Judge Bongaigaon in special within bracket NAR case number 127 within bracket BGN/2023, whereby the prayer for Zimma of the seized vehicle made by the petitioner was rejected. Let the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for. Let also a report be called for from the officer in charge of which police station? Bongaigaon Police Station, as to whether any confiscation proceeding has been initiated to confiscate the seized vehicle, that is within bracket Maruti XL Smart Hybrid Jetta bearing registration number
It was not registered, the new vehicle, my lord.
Jetta.
In paragraph 3, my lord, I have mentioned the chassis number and engine number, my lord.
Zeta in connection with aforesaid case. Stop. Let this case be listed again on after 23rd October.
Can you be little earlier, my lord? The vehicle is in very dilapidated condition, my lord.
With after vacation, it will be
14 or 15 is possible.
15th October.
24.
Yes.
The principal before it was husband and wife. Well, 2008. Informant has been made a party in response number 2 method, and really happily made it live method. And further pendency, the further pendency of proceeding is amount to abuse of the process of the.
What is the stage?
There's my appearance stage, my lord. Last day we have appeared, my lord, that you have imposed the order, my lord, the lordship, my lord. That is on page 35, my lord.
I've appeared, my lord, and it was fixed on 2012-2025 for copy. So, my condition, my lord, since they are staying together, husband and wife, and already this matter is settled, they have got 2 children, my lord. And so, further proceedings will amount to abuse
Mr.
of person.
Parashar, anything you have to say?
24.
Copy to morning.
Our name has not been shown, my lord, and we are, petition also not given, madam.
You furnish a copy.
Copy was already participated, but maybe.
My name no shown. Like a human around. Ashe, but we are not there.
Heard, Mr.
Sati Chamila.
Who is respondent number 2?
That's one about this father of the girl, my lord, informant.
What is their relationship?
He was a bailor earlier in point of time.
Heard, Mr.
Informant.
P. Kotoki, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely Sunil Narjari alias Suno Narjari and Jyoti Narjari alias Jyoti Kumari. Impugning praying for quashing of the proceedings of PRC case number 2995/2021 arising out of Latasil PS case number 25/2020 under section 366/376 of the Indian Penal Code pending before the Court of Learned Chief Judicial Magistrate, Kamrup Metro. Learned counsel for the petitioners submit that the petitioner number 1 is the accused in the said case, whereas petitioner number 2 is the victim. He submits that both the petitioners are married and are happily staying as husband and wife
2 children.
with 2 children born out of the said wedlock. The petitioner number 2, the victim, is presently 34 years of age, whereas petitioner number 1, the accused, is 37 years of age. Learned counsel for the petitioner submits that in the charge sheet, it has been alleged that the victim girl, that the victim within bracket petitioner number 2 was aged about 14 to 16 years at the time of commission of the alleged offense. However, he has produced a school. Where is the birth certificate?
Page 38, annexure 7, page 38, annexure 8. School living certificate.
Produced a school living certificate wherein the date of birth of the victim, Jyoti Kumari, no, don't name that. Victim has been shown as 18/12/1991 and which makes 18/12/1991, and if the age of the victim is computed taking that date into consideration, she would be 19 years of age at the time of the commission of alleged offense. Learned counsel for the petitioner has submitted that the charge sheet in this case has been laid after a gap of almost 10 years, when the victim as well as the accused are happily married, happily spending their marital life as husband and wife with two children born out of the said wedlock. He submits that where is the observation of the apex court?
The second paragraph, my last paragraph, my lord. Then that if a party settles the dispute amicably, continuation of trial would not serve a meaningful purpose. It would only
He
prolong the.
submits that, as in this case, the petitioners are living happily as husband and wife. The continuation of the trial would not serve any meaningful purpose.
There would not be a productive outcome.
And it would be only prolonging the distress for all concerned. He submits that under such circumstances, the apex court also observed that cases of such nature are liable to be set aside and quashed. In support of his submission, he has cited a ruling of the apex court in the case of Madhukar and others versus State of Maharashtra and others, another, reported in 2025 SCC online SC 1415. Stop. Issue notice to the respondent number 2, the petition, and call for the case records of PRC case number
Yes, case number, my lord,
2995/2021 from the Court of Learned Chief Judicial Magistrate, Kamrup Metro. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on November 6th, on 6th of November. In the meanwhile, considering the submissions made by learned counsel for the petitioners as discussed in the foregoing paragraphs, further proceedings of PRC case number 2995/2021 pending before the Court of Learned Chief Judicial Magistrate, Kamrup Metro is stayed until further order. List accordingly. For the reasons mentioned in the judgment, the proceedings of Jorat PS case number 2257/2020 is hereby quashed.
May it please the law.
Yes.
My lord, seeking your loss of indulgence, my lord, with respect to item 32, when it's a criminal admission matter, my lord. It is the third day it has come, my lord. So if your lordship kindly takes up the matter before your lordship rises.
32.
Otherwise, in by his view of serial, it may not.
It
reach,
is a
my-
fresh matter.
A fresh matter, man. Admission, criminal
32.
admission. Only 3 months imprisonment, man, fine of rupees 1,000.
Yes.
My lord, the appellants are the victims of a cross case which was filed by the other side as a counter blast. In our case, my lord, one of our person was killed within the courtyard of our house. They entered. And in the cross case, we are also given the imprisonment of 3 months and fine of rupees 1,000. This is the further matter.
Okay, in the main appeal,
Yes, ma'am.
we are admitting the matter. heard Mr. M.H. Rajbur Bhuya, learned counsel for the appellant. This appeal under section 415 within bracket 2 of BNSS has been filed by the petitioners Shahir Ahmed Bhuya and how many others?
Total 14.
And 12 others. And 13 others, impugning the judgment and order dated 25/7/2025, passed by the Court of Learned Additional Sessions Judge FTC Kachar in Sessions Case number 6/2013, whereby the petitioners were convicted under section 147 of the Indian Penal Code and were sentenced to undergo imprisonment for 3 months and to pay a fine of ₹1,000, and in default of payment of fine to undergo further simple imprisonment for 1 month. The petitioners were also convicted under section 323 of IPC and were sentenced to undergo simple imprisonment for 3 months and to pay a fine of ₹1,000 in default of payment of fine to undergo further simple imprisonment for 1 month. They are also convicted under section 341 of APC and were sentenced to undergo simple imprisonment for 3 months and to pay a fine of ₹1,000 in default of payment of fine to undergo further simple imprisonment for 1 month. This appeal is admitted for hearing. Let the records of the trial court be called for registry to take steps for requisitioning the trial court records list accordingly after receipt of the trial court records. I is there.
Yes, ma'am. I
Heard Mr. Same. This interlocutory application has been filed by the petitioners, namely Sahir Ahmed Bhuya and 13 others under section 430 of BNSS, praying for suspension of sentence imposed on the appellant by judgment and order dated 25/7/2025, passed by London Additional Session Judge FTC Kachar in Sessions Case number 6/2013. By the said judgment, sentence imprisonment similar to main case. The petitioners have impugned the aforesaid judgment by filing the connected criminal appeal number 328/2025. Learned counsel for the petitioner has submitted that since the sentence of imprisonment imposed on the petitioners is for a short period of 3 months only against each of the penal provision under which they were convicted, unless the same is suspended during the pendency of the connected criminal appeal. The criminal appeal, connected criminal appeals, it may become infructuous. Stop. I have consider the submissions made by learned counsel for both sides. Since the sentence imposed on the petitioners is for a short period of 3 months only, and since the connected criminal appeal has already been heard, has already been admitted for hearing, this is a fit case where the sentence imposed on the petitioners, on the applicants may be suspended during the pendency of the connected criminal appeal. Same is accordingly done. You are on bail.
Yes, my lord, we are made.
The
Previous bail, my lord.
the petitioners are allowed to remain on the previous bail granted to them by the trial court during the pendency of the connected criminal appeal. This interlocutory application is accordingly disposed of.
Much obliged. I think it's L2, I think 41.
It's not normal.
No. I think 85.
May I know? This petition is for quashing of the FIR, lordship, and this petition is for quashing of the FIR, lordship, and it is joint petition, lordship, filed by the informant and the accused, lordship. Petition number 1 is the informant, lordship. The FIR is paid, lordship, translated with page 10, lordship.
What is the stage?
Lordship, investigation, lordship. FIR is page 10, lordship.
What is the offense?
Lordship, it is registered as 87, lordship. This is kidnapping. 8735 BNS. Lordship, what happened, lordship? In paragraph 2, lordship, I have stated, lordship, petition number 1, who is the informant, and the petition number 2.
You are on bail.
Lordship,
You are on bail or not?
no, lordship, they have mutually understand the matter, lordship, because he himself, the petitioner number 1, the informant himself stated that, lordship, it is due to misunderstanding, lordship, paragraph 4, lordship, page 4, paragraph 3, lordship, I have stated, lordship, due to misunderstanding and, lordship, the misguidedly he has lost this FIR, lordship.
Where is the FIR? Page
Where?
10.
Page 4, paragraph 3, lordship, the statement. FIR is page 1.
Then let the investigation go on. Ultimately, truth will be found out.
Lordship,
If there is no material, FR would be submitted.
Lordship, this is, lordship, what happened, lordship, they are now settle the matter, lordship, and it is because of a partition dispute, lordship, among the petitioners, lordship. I have stated in paragraph 2, lordship, and page 3, lordship, paragraph 2, lordship. Petitioners number 1 and 2 are cousin
No,
brothers.
that is your story. The FIR discloses an offense. Plain reading of FIR, it
Yes,
discloses an
But
offense.
the FIR, the informant himself stated before your lordship that it is because of
No,
misunderstanding.
informant can say so before the IO. I will file the final report.
IO lordship, they have lordship also submitted the
Charge
lordship.
sheet.
No, they have also submitted the they have also informed the matter to the IO lordship. But IO is not accepting this matter. That's why lordship they are going to file this.
Where is that statement?
Lordship, this statement is not there, lordship. But if
It has to be there. Otherwise, this is not a case.
and lordship, I have also addressed lordship the judgment lordship. Why lordship this honorable court also lordship page 24 lordship this honorable court lordship coordination of this honorable considering the judgment of honorable apex lordship that aside lordship paragraph page 29 lordship paragraph 14 lordship which is 11 paragraph lordship.
set aside the FIR lordship.
That is the final date. Yes, Mr. Raj.
And there is,
You are on bail or not?
before going to bail, they have lordship, analyzed fact lordship that he has realized that.
Now what relief you are seeking?
But if we are paying lordship to set aside this FIR lordship. And
So
we want
for
to-
setting aside, we would require case diary.
Lordship,
We'll call for the case diary.
lordship, further investigation maybe.
Investigation cannot be stopped.
If no
The
material.
Apex Court has time and again stated the FIR which discloses offense, investigation cannot be stopped
But the
without
informal,
perusal of the
but
case.
the informal lordship, he himself stated that there is, the petitioners, the accused lordship are innocent. And there is, due to his misunderstanding and misguided,
Okay,
he
let us
filed this
peruse the
FIR.
case diary. Heard Mr. AMS Majumdar, learned counsel for the petitioners. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners praying for quashing of the FIR dated 25/6/2025. Filed by, who has filed the FIR?
FIR is filed by petition number 1, Ali Hussain Lashkar.
Filed by the petitioner. Where is he?
Okay.
Where is his signatures?
His signature is Dr. Ali Hussain, page 14. Page 14, Banakular lordship.
No. Who has sworn the affidavit?
Ali Hussain himself. No. Page 9.
By the Kili. No, not filed by the petitioner. Last words, Ketakati. It appears that the FIR, this instant application has been filed jointly by the informant as well as the accused persons. The informant Ali Hussain Laskar, alias Muhammad Ali Hussain Laskar, who had lost the FIR in this case, has himself sworn the affidavit supporting the application under section 528 of BNSS in this case. Perusal of the case diary would be necessary. Hence, call for the case diary after. Release this matter on 17th October. In the meanwhile, as the informant has himself approached this court along with the accused persons, seeking quashing of the FIR filed by him, further proceedings of Pochugadam PS case number 28/2025 shall remain suspended till the next date. List accordingly.
Item 28.
Please, your lordship.
I'm aggrieved by the fact that my petition for custody of my vehicle, Tata Nexon, was rejected by the learned judicial magistrate, my lord. What happened was that on the night of 6th of August, my vehicle was intercepted by the officials of Bokisto police station, and 8 boats were found inside the vehicle, lordship. I am the owner of that vehicle. I had actually given my vehicle to on rental basis to a company called Messrs. Arohi. It is a rental agency, lordship, and I have annexed the deed of agreement with this petition at page 21, lordship. It had already been given to them, and they had sublet it to another person, which document also I have annexed. At page 21, lordship, is the deed of agreement.
Yes.
I am Mr. Rupjyoti Borman. I am the owner of the vehicle, and this agreement was with Messrs. Arohi.
And
They-
to whom they have subletted?
They have sublet it to one Mr. Javed Ansari, which is at page 25. Javed Ansari had taken the vehicle on rent, lordship, and when it was intercepted, there were 2 different persons, namely, lordship, Nasib Ahmed and Mohidul Ali. So these 2 persons are the main accused persons.
Where is the rejection?
At page 29, lordship.
What is the ground on which it was rejected?
It was rejected, my lord. I had not appeared before the police station, although I was not directed, but I had not appeared before the police station, and therefore the investigating officer submitted a report that the ownership of the vehicle is yet to be ascertained, and no person has appeared so far to produce relevant documents in respect of the seized vehicle.
But you filed a Jimma petition
I filed a Zimma petition.
along with the RC and other
Everything,
documents.
lordship. Now, the trial court could have said that ascertain the ownership and handle.
Yes.
Without ascertaining to whom it can be given.
No, but
If
whether
they
when-
annex
when-
the document.
when they have annexed
the
the
document.
document. Heard Mr. S. De, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Rupjyoti Burman, impugning the order dated 29/8/2025, passed by London Judicial Magistrate First Class, number 5, Kamrup Metro, Assam, whereby the prayer for Jimma of the vehicle which was seized in connection with Vashishta PS case number 406/2025 was rejected. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the Tata Nexon vehicle bearing registration number AS01 PVFV 9637, which was seized in connection with the aforesaid case. He submits that you have submitted the RC
Yes, yes, lordship, all the documents.
before this court
Yes, at page 22, lordship.
to support his contention regarding the ownership of the vehicle. The petitioner has produced the registration certificate of the said vehicle, which is in the name of the present petitioner. Learned counsel for the petitioner has further submitted that the petitioner has let out his vehicle to a firm, namely Messrs. Arohi, by entering into a deed of agreement on 18 June 2025. He further submits that the said firm Messrs. Arohi had sublet the said vehicle to one person named Sai, with whom the possession of the vehicle was at the time of commission of alleged offense. He further submits that when the vehicle was intercepted and seized in this case, two other persons, namely, what are the names?
Nasib Ahmed and Mohidul Ali.
Nasib Ahmed and Mohidul
Ali.
Ali.
Mohidul Ali.
Mohidul Ali were found in the said vehicle. He further submits that the trial court, while rejecting the prayer for Jimma, had erred in stating the reason for the rejection that the ownership of the said vehicle was not yet ascertained by the investigating officer. He submits that at the time of filing the Jimma petition, the registration certificate was produced before the learned magistrate. You have produced,
Yes.
which was not considered by the learned magistrate. I have considered the submissions made by learned counsel for both sides and have. What is that case? Sundar Bhai Ambalal.
Ambalal Desai Lordship.
The apex court in the case of Sundar Bhai Ambalal Desai
2002 10 SCC 290.
reported in 2002 10 SCC
290.
219 has observed that after the vehicle has been seized in a case, it is of no use to keep such seized vehicle at police station for long period. And it is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicle if required at any point of time. In the instant case, it is not a case that the vehicle has not been claimed by anyone, though, the petitioner did not approach the investigating officer at the first instance and had approached the trial court seeking Jimma. However, that in itself cannot be a bar for granting Jimma of the vehicle seized in a case to its owner if he undertakes to produce the said vehicle as and when so required for the purpose of either investigation or trial. In view of above discussion, the impugn order dated 29/8/2025 passed by learned judicial magistrate first class number 5 Kamrup Guwahati is hereby set aside. The learned judicial magistrate is directed to no the in line to continue. The investigating officer of the which PS case number of the Vashishta PS case number 406/2025 is directed to give the Jimma of the said vehicle on furnishing on the petitioner furnishing a bond of rupees. How much? Cost of the vehicle?
Single lordship, it would be more than 10 lakhs, I believe.
Bond of rupees 10 lakhs with a condition to produce the vehicle as and when so required for the purpose of investigation or the trial. At the time of giving the Jimma of the vehicle, the investigating officer shall prepare an inventory of the vehicle and also take photographs of the vehicle from various angles. And after giving the Jimma, submit the Jimma Nama along with the inventory and photographs to the trial court so that same may be kept in the record of Vashishta PS case number 406/2025. With above observation, this criminal petition is accordingly disposed of.
Most obliged. Item 29.
May it please refer, by way of instant criminal petition, the petitioner had challenges the framing of charge lordship against the petitioner lordship. The relevant page is page 44 lordship. And except
What are your grounds?
the acceptance was there lordship, but the demand was not there lordship, as per conversation of the other co-accused lordship, annexer 8 lordship. Page 53 lordship.
Charges are framed under such, okay. Okay. We'll call for the case diary.
Lordship may rely upon what the
Scan copy of the case diary.
every time lordship proceeding may be state
No,
lordship.
no.
Demand part is not there lordship, essentially.
No, we will examine that.
That is correct.
You have
lordship.
already appeared. Heard Mr. M.K. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Jairam Das alias Jairam Das, impugning the order dated 30/7/2025 passed by the Court of Learned Special Judge Assam and Guwahati in special case number 12/2024, whereby the charges under section 7 within bracket A of the Prevention of Corruption Act 1988 has been framed against the petitioner. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode, returnable on, yes, Putul, returnable on 22nd October. Let also the scan copy of the
Yes.
trial court records as well as the scan copy of the connected case diary be called for list accordingly.
The till the returnable date kept in evidence lordship at least.
No.
230.
May I please the lordship? Here, this is an application lordship under section 528 of the NSS lordship, as from the certificate case lordship.
Here, Lordship, out of 3 solicited accused, Lordship, 2 already allowed on go and bail, Lordship. And the present petitioner is declared absconder, Lordship. Now the case is registered as PRC case, Lordship, which is pending before the additional CJM, Lordship, Kamrut Metro. And after taking cognizance, Lordship, summon issued, Lordship.
Summons have been issued.
Issued, Lordship. Here, Lordship, out of 2, Lordship, and out of 3, Lordship.
What
three
you are
accused.
challenging?
I'm challenging on behalf of Samuna Begum, Lordship.
No, which order? You are agreed with what?
Actually,
You are challenging the cognizance taking,
cognizance order,
only
Lordship.
cognizance.
21/3/2024, Lordship. Cognizance was taken, Lordship, against the petitioner, Lordship, under section 120B and 302, Lordship, which is exclusively tried by the Court of Session, Lordship. So, Lordship, apprehension is there, Lordship. If the petitioner appeared, Lordship, they've taken custody, Lordship. This is the.
Then 528 is not the appropriate provision. You should have approached this court under 482.
In some cases, Lordship, I preferred in under section 482, Lordship. Then, Lordship, coordinate bench, Lordship, saying that you file appropriate application under section 528, Lordship. So, Lordship, I filed.
No, this on. Let me see.
Lordship, FI is very clear, Lordship. My name, I'm not the named FI accused, Lordship. FI is at page 12, Lordship. May kindly come to the.
No,
FI.
you have already challenged the order taking cognizance.
Yes, Lordship.
We are calling for the records.
Lordship, next date is fixed, Lordship, on 19, day after tomorrow, Lordship.
Yes.
So, Lordship, I will appear, Lordship, I will face the trial, Lordship. So some protection may be given, Lordship, and in the next date, I will definitely appear, Lordship.
Main case is under section 120.
Protection under 528 is when you have specific provisions.
Yeah, Lordship. 232 is bar, Lordship. That's why, Lordship, because they're only the committal code, Lordship. So if I appear, Lordship, 302 is there, Lordship.
No, that is correct. But there are other provisions. If you are anticipating that you may be detained behind the bars, then 482 is there.
Yes. So, Lordship, if Lordship may kindly protect, Lordship, then I will appear.
528 protection,
Lordship, day after tomorrow, the date is fixed, Lordship.
What kind of protection you are seeking?
Protection, Lordship. Directed me to appear, Lordship. on
You appear,
such-
that is granted. Thereafter,
After, Lordship, no course action shall be taken, Lordship, at least.
what coercive action?
Because the additional is in only the committal court, Lordship.
No, what do you mean by coercive
in the
action?
form of bail mallet can be
Lordship, as per the provision of section 232, Lordship.
On that I agree,
Yes, Lordship.
that the trial court may not grant you bail. The committal court may not grant you bail, but what relief you are seeking? You are seeking the relief of bail. For bail, a specific provision is there in the statute. And when there is specific provision, can you take recourse to 528? That is my query.
Actually, in some coordinate bench, Lordship. This
No,
thing has happened, Lordship. So-
you just persuade me that in spite of having specific provisions, 528 can be exercised. Otherwise, in that cognizance order, it is okay. Heard Mr. A. Borua, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by Samuna Begum, impugning the order dated 21/3/2024, whereby the cognizance of offense under section 120B/302 of the NDP of the Indian Penal Code has been taken by the court against the petitioner in PRC case number 2382/2023. Let the scanned copy of the case diary of Sonapur PS case number 95/22 be called for. Let also the scanned copy of PRC case number 2382/2023 be called for. Let this case be listed 22nd of October.
After vacation, before vacation, cannot be. Additional CDM cannot be followed.
Okay, 26th of September. You come on that day with answer to my queries.
Yes, sir.
None has appeared for the petitioner on call. Let this matter be listed.
Last petition also probably in non-NDPS looks.
Mr. Paul is there.
I have 33.
Yes.
Which I heard the report has not been received as of yet.
Huh?
The service of notice purchase.
Poxo matter.
Yes, Lord.
Lord, this application has been filed 2 months ago, my lord. Since then, it is waiting for, it would be better to appoint a amicus curiae.
They did not take steps purchase.
Huh?
NP they took steps purchase.
You
Not
took,
recently to be, we have taken step on 21/8.
38, there is a office note.
21/8, it was taken step, lordship now.
but the office note says you
There
took,
was a letter on office note has been rectified that yes, on 21/8 steps taken, but it was received by them lately.
what is the offense? Poxo.
In that case, possible, amicus may be appointed.
Heard Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears from the record that though the petitioner has taken steps for issuance of notice on the respondent number 2 on 21/8/2025. However, the report of service of the notice has not yet been received. Considering the fact that the petitioner is detained behind the bars since when?
30 January 25.
Since 30 January 2025. This court intends to appoint one amicus curiae to defend the cause of the respondent number 2 in this case. Accordingly, any amicus? Yes, accordingly, Mr. S. Nawaz, learned counsel for the petitioner. S. Nawaz, learned counsel whose name appears in the list of amicus curiae prepared by the registry is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall furnish a copy of bail application along with annexures to the amicus curiae, to the learned amicus curiae. The registry shall reflect the name of Mr. S. Nawaz as amicus curiae for the respondent number 2 in this case, in the cause list henceforth. Case diary is there,
Considered matter.
the scan copy is there. No?
And provision
Okay, let this matter be listed when.
22 or
So
20.
may I pray also the records to be updated also because last occasion it was.
No, it will take some more time because no charge has been framed till date. So far as my instruction.
In the month of July it was.
But we don't know.
If
31
LCR has been called for, then it will, vacation will go.
31/7 it was fixed also. What happened on?
What
31/7?
happened on 31/7?
I have no instruction.
So therefore, we have to take instruction. Let us up-to-date status report of the trial of trial in the case of special POXO case number
04/5/25. 45/25.
special case number 45/2025 be called for from the trial court. Let this case be listed. Reopening date 13th of October
14.
for 14th October.
Can it be prior to that, because he has taken another plea with regard to, we may obtain oral instruction. If your lordship would agree to hear me or within a short date before vacation.
What is your ground?
I have awarded my additional affidavit, the grounds on being perusal of the LCR. Those are preliminary grounds of that there is no grounds of arrest communicated. Second thing that there is from medical report, no recent sexual intercourse have been found. Third thing is that my name is not in the confessional statement. So these are my basic grounds. Or other main
Okay,
culprit is on Somar
on 26 name.
published.
That yet connected case has been
Yes.
listed on when?
On 26 September.
This heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Ms.
R. Hussain, Your Lordship.
R. Hussain, learned counsel for NCB, who prays for an adjournment. The prayer is allowed. Let this matter be listed on 26 September.
This CD has not been received.
Lordship, this is the first that matter, 39 is Your Lordship. Scan copy has already been received, Your Lordship. Staff report scan copy. And in this case, Your Lordship, the 48, section 48 is not comply, Your Lordship.
So after some time. also I'll
And
go
Your
to the
Lordship, I have a,
I'll just go to the records. first. After some time.
Okay, let him go through the record. Wait for some more time. Let him go through the record. We'll take it after as next item.
Lordship, regarding illegal mining at Timbrang Soma.
CD has not been received. Lordship.
Now, my lord, petitioner before your lordship is the manager of the prime accused. My lord, that will reveal from the, my lord, forwarding report, my lord.
What case diary would be required?
Now, my lord, co-accused lordship. The number of cases, of course, this under report, my lord.
Next
And
week
lordship granted them bail, my lord. And here, my lord, kindly have a look, page 14, my lord. Lord, serial number 5, my lord. 1 for my lord. Investigation of the case also revealed that arrested accused so and are managers of prime accused Punush Nunisha, my lord. And they are not only look after the financial matter, but also supplied machineries in such. Now, like, he is the manager, my lord.
How many days you are behind the
My
draw?
lord, today 25 days, my
Lordship will kindly peruse page 27.
20?
7.
Rejection order. Lordship, where
Yes.
27 Lordship will be paragraph on further perusal of the case report. It appears that accused Jamal Ali.
You are Jamal Ali.
Yes.
Kamal Ali.
Lord, he admitted-
Manager of the crime accused and Jamal Ali Sona looks after the financial matters relating to illegal coal mining. And as per the forwarding report, bank account statement of the accused. You produce the case next week. Heard, Mr. J. Laskar, learned counsel for the petitioner. Also heard Mr. K. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case. Prayer is allowed. Let this matter be listed. When?
23rd.
On 23rd of September.
Can it be on 20? Apply.
49.
Please, your lordship, no. Lordship, on the page
Oh,
number,
whether you have gone through. You have gone through.
lordship,
Yes.
page number 26 is the rejected order, your lordship. Page number 26, last page. Rejected order of the trial court.
Yes.
Yes, lordship. This is the bail application for the accused Firuz Alam and Mohammed Mujibur Rahman arrested to the connection with the GLIPS case number so and so, had both sides. Peruse the case record. The WT message was communicated to SHO Thobal in Manipur, requesting to SHO to inform the family members of the arrestee. The arrest memo specifically shows that the accused were arrested for being found in possession of commercial quantity of morphine. In that view of the matter, there is substantial compliance of Article 22 Clause 1 of the Constitution of India and the procedural requirements under the BNSS 2023. As the case at hand concerned commercial quantity of contraband, the rigor of Section 37 of NDPS Act does not allow me, in the facts before me, to grant bail for the two accused persons. Lordship, it is with the above order, the bail application is sent disposal. And your lordship, I have annexed the arrest memo of the page number 23 and 24 for the both accused person. In this arrest memo, your lordship, there have no any signature of the relatives of the accused person, your lordship. And 48 is not complying in this case, your lordship.
Where is notice under 48?
Lordship, 48 is not comply, your lordship. On the paragraph number 8 here mentioned, name and address,
I have
email
not
ID,
found
telephone, robo mukodio. No number whosoever to convey the arrest information WT transmitted. Means WT message is sending but not received by the accused person, sorry, relative of the accused person. And at first, kindly your lordship may allow to submit the criminal appeal 234/25, your lordship. Well, on the paragraph number 17, your lordship, here mentioned in this case, paragraph number 17, your lordship. Paragraph number 17 here mentioned. We have perused the records that have been brought by the appellant, though there is signature in the photocopy of the arrest memo of the accused or respondent, which the appellant say is the signature of the brother of the accused. We find that there is no date affixed to the said signature. On the other hand, all the other signatures in the arrest memo, which have been signed by the witnesses, the arrestee, and the officer making the arrest, all the dates, there is nothing to prove that the grounds of arrest had been received by the brother of the accused respondent on 25/2025. In that view of the matter, the submissions made by the learned counsel for the appellant that the brother of the appellant had been given a copy of the arrest memo on 25/2025 is not proved, and the said submission does not inspire our confidence. Furthermore, as stated earlier, the appellant in their written objection to the bail application filed before the learned special court near Assam had specifically taken a stand that the grounds of arrest of the accused respondent had been given to the father of the accused respondent. This stand has, however, been completely changed in the present appeal, which has been filed on 2/6/2025. And your lordship, paragraph number 15. Kindly go to paragraph number 15. Sri Darshan, your lordship, the Supreme Court had negated the
Okay,
submission.
okay, okay,
Yes, lordship. And
yes,
lordship, Bihan Kumar judgment also, lordship.
okay.
Yes, lordship, on the last para,
Yes,
your
what
lordship.
is the submission?
Sure, copy of notice I have not found in the report.
Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners. Who is the petitioner? Two petitioners.
Petitioner Firuz Alam and one is Majbur Rahman.
Petitioners, namely Firoz Alam and Mujibur Rahman, who are detained behind the bars since 30/4/2025 in connection with
Delay PS case number 25/25.
Delay PS
Case number 25/25.
25/25 under section 21C/25/29 of the NDPS Act. The gist of accusation. Where is the FIR?
FIR is, your lordship, page number 15.
The gist of accusation in this case is that on on 30/4/2025, one Mintu Soika, SI of police, had lodged an FIR before the officer in charge of Delhi police station, inter alia, alleging that during routine Naka checking duty at National Highway number 29 at 6 Mile near Forest Beat office under Lahorijan police post on 30/4/2025. One Renault Duster vehicle bearing registration number BR01DA 6016 was intercepted, and during search of the said vehicle, what was found?
Lordship,
What was found?
morphine, your lordship.
How much?
4 kg something, lordship.
Mm,
Morphine, your lordship.
4.096
6.
4.096 of morphine was recovered from the said vehicle. Stop. Learned counsel for the petitioner has submitted that the petitioners are seeking bail in this case on the ground of breach, on the ground of violation of their fundamental rights guaranteed to them under Article 22(1) of the Constitution of India, in as much as no notice under Section 48 of BNSS was served on the family member, on the friends/relatives/nominated persons of the accused person. Learned counsel for the petitioner has further submitted that the trial court had rejected the prayer for bail of the petitioner mainly on the ground that on perusal of the case diary, one WT message was found whereby the said message was sent to station head of a station house officer Thaubal in Manipur, requesting him to inform the family members of the arrestee. Stop. Though she submits that though the trial court held that there is a substantial compliance of Article 22(1) of the Constitution of India in this case. However, there is no material on record to show that, in fact, the grounds of arrest were communicated to the family members slash friends slash communicate slash nominated persons of the petitioners. She further submits that in the arrest memo prepared by the arresting authority, only the signatures of the accused petitioners have been taken, and it does not indicate anything that the said arrest memo were communicated to the family members slash friends or nominated persons of the petitioner. She therefore submits that there is a violation of the statutory requirement of Article 48 as well as constitutional mandate of statutory requirement of Section 48 of BNSS as well as constitutional mandate of Article 22(1) of the Constitution of India in this case. And on that ground, the petitioner, he submits that the petitioners may be allowed to go on bail. In support of her submission, learned counsel for the petitioners has cited a ruling of the apex court in the case of Vihan Kumar versus State of Haryana and another, reported in 2025, 5 SCC, page 799, as well as a ruling of the division bench of this court in the case of National Investigating Agency versus Hang Min Len Mate, alias Lelin Mate, within bracket, order dated 21/8/2025 in criminal appeal number 234/2025. On the other hand, learned additional public prosecutor submits that though the contraband seized in this case is of commercial quantity and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. However, she fairly submits that she could not find notice under Section 48 of BNSS in the case. Stop. The apex court has observed in the case of Vihan Kumar versus State of Haryana in another report, so within bracket Supra, that the requirement of communicating the grounds of arrest, comma, in writing, comma, is not only to the arrested persons, comma, but also to friends, relatives, or such other persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22 within bracket 1 of the Constitution of India meaningful and effective, failing which, comma, such arrest may be rendered illegal. Stop. In the instant case, apparently there is nothing to show that the grounds of arrest were communicated in writing to the family members, comma, friends, comma, nominated persons of the petitioners. Stop. Merely sending a WT message to the officer in charge of the concerned police station where the family members of the petitioners are stated to reside in itself does not fulfill the requirement of within inverted comma, communicating the grounds of arrest, inverted comma close, to the family members slash friends slash nominated persons of the petitioners. As such, in this case, the prosecution side has failed to prove that the grounds of arrest were communicated in writing to the family members slash friends slash nominated persons of the petitioners. And therefore, on that ground, they are entitled to get bail. Accordingly, the petitioners are allowed to go on bail of rupees 50,000 each with 2 sureties of like amount, subject to the satisfaction of learned special judge Arbyong Long Defu with following conditions, trial conditions. With this observation, the bail application is hereby disposed of.
41.
Lordship, and one of my same case, your lordship, item number 61, your lordship.
Wait for 61.
The same case, your lordship. This is a
Arising out of same police station. Same police station. So,
lordship, and I have submitted the arrest memo in this case, your lordship, 61 item.
different case or same case?
This is a different case, but same police station. Different
You have to submit honestly before the court.
that this is the same police station, but different case number.
Wait for your turn.
Much of it.
41. Made please, my lord. Custody is in the last 44 days. Now.
Charges submitted.
What is the offense?
My lord, under section 61(2), 109, 1172, and 189 of NDPS.
You approach before the trial court.
My lord, 21 similar situated persons have already been granted the privilege of absolute bail. In fact, all of these are my lord's order only. And in the last order, my lord may kindly.
Anticipatory bail.
No, my lord, regular bail. Regular bail too, my lord. I would just draw the honorable court
No,
attention.
but now the charge sheet has been laid.
My lord, clarity is there. The last order, my lord, 6/8/25 order, my lord, passed by this honorable court, where a similar person was granted bail. He was also behind the bars for last
The problem
45
is,
days.
the problem is charge sheet is not before us. So we do not know. We may not appreciate your submissions without the charge sheet. Now we have to call for the charge sheet. Scan copy of the charge sheet. It would be better for you to go to the trial court.
Otherwise, my lord, the charge sheet, from what I have received from my learned counsels from the opposite side, it is with them, my lord, the charge sheet today. Charge sheet has been filed. So if my lord peruses, if it pleases my lord, then also, my lord.
No.
Because it is with the, it is there with them, okay, my.
No,
Because
charge sheet is not.
The WT message that charges submitted.
Heard
but
Mr. P.R.
charges
Sharma,
not.
learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
5/25.
dated
Dated 13/09/25.
in view of the fact that the charge sheet has been submitted in this case. This bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Deeply obliged.
It has not been achieved.
After some time. We'll
Lordship, in this case, your lordship, 48 is not comply, your lordship.
Case diary has not been received.
So I submitted the arrest memo, your lordship. There have also no any signature of the relatives of the accused person, your lordship. And I have submitted the arrest memo in page number 20. Yes, lordship, 20.
Whether 48 is there.
No, 48 is not comply in this case, your lordship.
Not compliant,
Not comply.
according to them.
And according to you,
So the perusal of the schedule.
unless you peruse the case diary.
The case diary has been received by the APP already checked the record also, your lordship. On that 9/9/25, they have received the case diary, your lordship. And taken the confirmation that the WT message they have received or not. For this reason, they have taken the time for today, your lordship. But your lordship, without the permission from the court, send back the case diary, your lordship. And we are waiting for the hearing, your lordship, today. And it is not my guilty, your lordship. And already on that day, that 11/9/25, on that day, your lordship, already, your lordship, they have confirmed that 48 is not comply, your lordship. APP has confirmed, your lordship. But after then, they have taken the time, they have submitted the 5 benches of judgment where is deny the Bihan Kumar judgment, your lordship. It is completely false submit, your lordship, before the court. So today is the date fixed, and I have submitted the arrest memo, your lordship. On the page number 20 here also no signature of the
Wait, slow.
and your lordship. This
No,
is the
listen to me. On the last date, the APP took the plea that the WT message have been sent to the concerned police station and has been served on the family member.
This is the order of the 11/9. Oh, sorry, 9/9. Yes, 9/9.
Now, what is your stand?
So the CD is not before us, lordship. Lordship may fix a date, will produce the case diary.
Lordship, I have the WT message, your lordship. I have found from the my client, your lordship, and on that day I have submitted before the honorable court, but they are not denied that this WT message was
How much
received.
is the contraband?
Commercial quantity.
Commercial quantity.
Let them file. Let them find out from the case diary. No, heard Miss A. Medhi. How much is the How much is the contraband
2 kg, your lordship.
of
Morphine.
Morphine, 2.127 kg.
heard? When can you find the case diary?
They may be fixed, your lordship.
Next week, look anything.
Monday, your lordship. Kindly, your lordship, Monday, because your lordship, I have submitted everything. On that day, court is
But
also satisfied.
suppose,
The bail, your lordship.
listen to me.
The-
I'll fix it after Puja vacation. Heard Mr. B. Sharma, learned counsel for the petitioner, who also heard Ms. A. Medhi, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who praised for some more time for production of the case diary. Considering the fact that the submission was made before this court by learned additional public prosecutor on 9/9/2025, that the case diary would reveal as to whether the WT message sent by the concerned police station has been served on the family members of the petitioner or not. The perusal of the case diary would be necessary. When release this matter on 24th September.
CD was false for me.
CD is there. your lordship.
Yes.
They have come against the notice issued under section 91.
Section 91.
Yes. CRPC. So it is otherwise also.
91 is for production of documents.
Earlier also I move a similar nature of case, my lord, your lordship
So,
granted
so
bail, my lord.
otherwise also it is not maintainable because we are expecting that he will cooperate us. He is the owner of the.
He is not the accused,
He is not the, as of now, he is not.
not the
accused.
accused.
Only for the purpose of investigation, he has been called. And now he is denying, and after getting the interim order from this honorable court, he is not revealing. He is not producing the document because he is under protection. That can be revealed from the record. Because while he was.
Now he is under interim bail.
Yes, my lord.
Yes, your lordship.
And-
Under section 91, this notice has been issued under section 91. And in the motion stage, he has been granted interim bail.
Okay, now he has appeared before you.
Even if he is appearing, he is not giving the reply.
What he's saying?
He do not know. He don't have the document.
So suppose if he don't have the
So
document,
yes, he is having, reason being, when he denied, thereafter, during the course of investigation, we have obtained this check, 2 checks. By way of check, he has made a payment to the public servant, railway official. And he was keeping on. Record is here. He has denied, and subsequently on auditing, because it is the matter of auditing, there are 300 transactions and parties. And it is a matter of more than 100 crores. Fabricated and false advertisement has been done. He is the owner of one newspaper, who is a very small newspaper. As per the Government of India specification, they have panel of the newspaper. However, the government official, they have given advertisement in these newspaper. They have originated a false and forged bill. And
no, we are not on that. Now it is your duty to investigate.
yes, sir.
The question is whether he is cooperating or not.
He is not.
In what manner he is not cooperating.
Yes, not given the reply, proper reply. Subsequently, IU has got this check.
So you
This check is
no,
showing.
no, that cannot be a ground. Suppose you have other avenues to find out evidence which you require. If he is not disclosing it,
Because it is, he is not disclosing, even this CD is also speaking. the
but
truth. He is giving a very evasive reply. This is.
you give me the case study. Heard, Mr.
23(8)
I,
also.
Rafiq, learned counsel for the petitioner. Also heard Miss M. Kumari, learned
Last of us, I need to flag to the.
learned standing counsel, learned special public prosecutor, CBI. Learned counsel for the petitioner, when you got the bail, learned counsel for the petitioner has submitted that the petitioner was granted interim bail by a coordinate bench of this court on 14/8/2025. And he has appeared before the investigating officer and has cooperated in the investigation. And therefore he prays for
He did.
making the interim bail absolute. On the other hand, learned special public prosecutor has opposed the making of the interim bail absolute on the ground that the petitioner is not cooperating in the investigation. In what manner not cooperating?
He
There
is
is
not giving proper reply
what is proper reply?
with regard to certain documents and the advertisement.
Suppose he is saying that
bill,
it is.
and with regard to the payment of bill, what he has received.
She
Definitely
also,
he wants the bill because he is giving the returns to the income tax department.
she also submits that in spite of having the documents required by the investigating officer, he is denying to produce the same stuff. In support of her submission, the petitioner has produced the case diary which contains the endorsement of the investigating officer to that effect. I have considered the submissions made by learned counsel for both sides. Keep the case diary with me. Take it back after the court hours.
And few extract are with me from there itself. It is in the last side. Check, I have already
You
folded. the
flag mark
page.
whatever is.
There are number of I have already folded the page, flag mark is there, but in the later side. Because what happened, your lordship, nowadays, when they got the entry order, they are not cooperating. They have taken it granted that I am not getting arrested. And these are the economic offenses. All are involved with the officials of the government.
Okay, I will consider your submission. We'll pass the orders in chambers. Do you have anything?
I can give the judgment, your lordship. Two judgment of the economic.
Well, the main allegation was against 6 railway officers, and it was lost by the SP in the year 2019. And the allegation was that in the name of advertisement of NIT in the newspaper, they have caused huge loss to the NF railway.
No,
And
that you have submitted while
Oh,
getting
yes.
interim bail.
Yes.
That is there in the interim bail.
Yes.
I'll
Now, the
pass.
money has been transferred to the public officials, family member also. The matter is still under investigation. So because of their non-cooperation, we are not in a position to conclude the matter. That is the.
Suppose the accused remain mum. He don't speak anything. Then what will you do? What the law says? This is my query.
And based on the document, we will have to.
You have to find out other evidence.
But that will be a hindrance on the part of the IU in the investigation.
Yes, that I will
That
consider.
is a serious issue and it is an economic offense.
That I will consider in my order.
But this is an notice under section 91.
Yes,
And say fundamental right is there, then fundamental duty is also there. They are supposed to cooperate.
okay. I'll pass orders in my chamber.
Fellowship, kindly consider annexure 5. The order passed by your lordship. Annexure 5.
Okay.
Oblige me.
So parity cannot be granted, your lordship. Because investigation.
This was item number? Yes.
So the issue here is regarding extension of the period of detention of an accused person under section 36A4 of the NDPS Act. Your lordship knows that whether it is under the NDPS Act or the erstwhile TADA or UAPA, whenever there is a prayer for extension of the investigation, there are certain requirements. One is that it has to be made before the expiry of the statutory period. Here that has been complied with. It's a commercial quantity case, statutory period is 180 days. The application was filed on 177th day. That part is complied. Now, law also mandates that when this prayer is made, then a notice has to go to the accused. Now, Hitendra Vishnu Thakur made it very clear, notice has to go. Well, I've already placed the authorities, I'll come to those. Hitendra Vishnu Thakur said notice is mandatory. Now, a constitution bench in Sanjay Dutt clarified it. It said that a notice need not be a written notice, but it is necessary that the accused has to be produced in court at the time when this prayer is being considered. So even if it's not a written notice, the accused is before the court at the time of consideration of this prayer for extension. In that case also, it will serve. So what the law really mandates is that the accused must be given an opportunity of hearing before extending that prayer. So in this case, my lord, when this application was filed, there was no notice was issued to the accused person. Accused person was not produced on the day when this petition was filed or considered. And without hearing the accused person, my lord, prayer was allowed. And further 180 days time was given. Now, your lordship will kindly, before the authorities, ma'am, your lordship will kindly come to page 35. 37, my lord. This is the PP's prayer, ma'am.
Thirty-seven.
37. Yes. So this was petition number 1479, 2025, dated 2/6/2025. Now, next page, my lord, is the IO's note supporting it. Now, your lordship will kindly come to page 41.
Who filed this application?
Application was filed by the PP.
Okay,
Initially, IO filed, but it was routed through the PP, so that part is complied with, my lord.
okay.
No infirmity in that part. Now, page 41, my lord. This is the order. Your lordship, remember the order petition was dated 2/6 and it was put up on 3/6. The case record is put up today on the basis of petition with so-and-so dated 2/6 filed by the learned PP, seeking extension of the period of investigation and custody of the accused Anzar Hussain as prayed for by the IO in terms of the provisions laid down under section 36A4 of the NDPS Act for enabling him to file the report in final in the case. It is stated by learned PP that the accused Anzar Hussain has already completed 177 days in the judicial custody since his arrest on 8/12/24. Heard learned PP as well as IO. So only they have been heard. Also peruse the petition filed by the IO as well as the materials available in the case record and the case diary. It appears that the IO has prayed for extension of the custody for accused Anzar Hussain on the following grounds. That forensic analysis of the seized contraband is underway and final report is yet to be received. That there is a strong apprehension that if released on bail at this stage, the accused person might abscond and might not appear during trial of the case, especially considering his access to the hideouts in neighboring states. That investigation is still ongoing and releasing the accused person on bail at this crucial juncture would severely hamper the process of impartial and effective investigation. There exists a high likelihood that the accused may influence key witnesses or tamper with critical evidence. There are several other co-accused suspected persons who are believed to have been involved in the supply and distribution of the contraband are yet to be identified and apprehended. The custodial detention of the present accused is therefore essential for tracing the wider network and ensuring a thorough investigation. Well, as far as the grounds are concerned, we have no quarrel on the grounds, my lord. These are otherwise genuine grounds. It appears from the material available on record that commercial quantity of contraband has been recovered from the possession of accused Anzar Hussain, and there is a possibility that the drug cartel along with which he is involved, which procures huge quantity of contraband substance for supply to the consumers in Nogao and other parts of the country might be unearthed. It seems the FSL report of the seized contraband is yet to be made available to the investigating agency. The IO is also apprehensive of the disappearance of the accused once he is released on bail in this stage. Accused Anzar Hussain has completed 179. It should be 177, but 179. Accordingly, considering the aforesaid aspects and circumstances, the prayer made by the IO is allowed. IO is granted a period of another 180 days to complete the investigation, and the detention period of the accused Anzar Hussain is accordingly extended by as many days by invoking the proviso of subsection 4 of section 36A of the NDPS Act. So here your lordship will notice that no notice to the accused person. Accused person is not produced. Records are also there, my lord, it's been flag marked that on the day when this order was passed or the day on which the petition is dated, there was no physical production of the accused. Production was subsequent. Now, your lordship, I have the authorities, my lord, which are there in the file, my lord. First is, my lord, Hitendra Vishnu Thakur, my lord.
Which paragraph?
Para 21, my lord. Hitendra Vishnu.
Okay. Para 21.
Para 21, my lord. And the second part of the para 21 has already been underlined, my lord, was already heard earlier. Yes, para 21.
Yes.
The underlined part, my lord. Similarly, when a report is submitted by the public prosecutor to the designated court for grant of extension under clause B, this is regarding 24 of the TADA, my lord, this is parameteria to 36. Clause BB, its notice should be issued to the accused before granting such an extension, so that an accused may have an opportunity to oppose the extension on all legitimate and legal grounds available to him. It is true that neither clause B nor clause BB of subsection 4 of section 20 TADA specifically provide for the issuance of such a notice. But in our opinion, the issuance of such a notice must be read into these provisions, both in the interest of the accused and the prosecution, as well as for doing complete justice between the parties. This is a requirement of the principles of natural justice, and the issuance of notice to the accused or the public prosecutor, as the case may be, would accord fair play in action, which the courts have always encouraged and even insisted upon. It would also strike a just balance between the interests of the liberty of an accused on one hand and society at large to the prosecuting agency on the other. There is no prohibition to the issuance of such a notice to the accused or the public prosecutor in the scheme of the Act, and no prejudice whatsoever can be caused by the issuance of such a notice to any party. This is the first judgment, my lord, where this issuance of notice was read into these provisions, my lord. Now, next judgment, my lord, where this was a bit diluted, was my lord Sanjay Dutt, my lord. Sanjay Dutt is a constitutional bench judgment, my lord.
Yes.
Rely on two paragraphs, my lord. First is paragraph 45, my lord.
Yes.
Paragraph 45. In Hidendra Vishnu Thakur, it was held that the designated court would have no jurisdiction to deny to an accused his indefeasible right to be released on bail on account of the default of the prosecution to file the challan within the prescribed time, if an accused seeks and is prepared to furnish the bail bond as directed by the court, and that a notice to the accused is required to be given by the designated court before it grants any extension under the further proviso beyond the prescribed period of 180 days for completing the investigation. Shri Kapil Sibbal, learned counsel for the petitioner, contended that the requirement of the notice contemplated by the decision in Hidendra Vishnu Thakur before granting the extension for completing the investigation is mere production of the accused before the court and not a written notice to the accused giving reasons for seeking the extension requiring the accused to show cause against it. Learned counsel submitted that mere production of the accused at that time, when the prayer for extension of time is made by the public prosecutor and considered by the court to enable such a decision being made in accordance with the requirements of Section 167 CRPC, is the only requirement of notice to be read in the decision of the division bench in Hidendra Vishnu Thakur. The grievance of the learned counsel was that quite often the accused was not even produced before the court at the time of consideration by the court of the prayer of the public prosecutor for extension of the period. Now, your lordship will kindly come to para 53. This is the submission, my lord, and then the finding of the honorable court, my lord. Para 53, 2A, my lord. Your lordship will find it in internal page 444.
Yes.
My lord. The section 24 BB of the TADA Act only requires production of the accused before the court in accordance with section 167, 1 of the Code of Criminal Procedure. And this is how the requirement of notice to the accused before granting extension beyond the prescribed period of 180 days in accordance with the further proviso to clause BB of subsection 4 of section 20 of the TADA Act has to be understood in the judgment of the division bench of this court in Hidendra Vishnu Thakur. The requirement of such notice to the accused before granting the extension for completing the investigation is not a written notice to the accused giving reasons therein. Production of the accused at that time in the court, informing him that the question of extension of the period for completing the investigation is being considered, is alone sufficient for the purpose. So here that written notice, my lord, has been interpreted by the Constitution bench to say
In the instant case, he was not even
not
produced.
even produced. No, no. Third is, my lord, Sanjay Kedia, that is specific to NDPS, my lord. Para starts from para 11, my lord. Relevant will be para 13. Lordship has para 13.
Yes.
My lord. The question to be noticed at this stage, here, my lord, para 11 is 36A4 and para 12 is 167.2. Para 13 is the question to be noticed at this stage is as to whether the two applications for extension that have been filed by the public prosecutor seeking an extension beyond 180 days met the necessary conditions. We find that the matter need not detain us as it is no longer res integra and is completely covered by the judgment of this court in Hidendra Vishnu's case. In this case, the bench was dealing with the proviso inserted in clause BB in subsection 4 of section 20 of TADA, which is in parimateria with the proviso to subsection 4 of section 36A of the Act. The court accepted the argument of the accused that an extension beyond 180 days could be granted, but laid a rider that it could be so after certain conditions were fulfilled. Para 14, my lord, Hidendra Vishnu Thakur is read. So here, my lord, this juxtaposition of 36A is done with TADA. That these are two parimateria provisions.
Okay.
The final judgment was a recent judgment, my lord, I've given. That is, my lord, Jimmy Elias Jigar Pachanda, my lord, Aditya, my lord. Here, my lord, starts from paragraph 35.
Yes.
Para 35, my lord. The question before us is about the legal consequences of the failure of the special court under the 215 Act to procure the presence of the accused at the time of consideration of the report submitted by the public prosecutor for a grant of extension of time to complete the investigation. In addition, we'll have to consider the effect of the failure to give notice to the accused of the report submitted by the public prosecutor. So para 36 is the provision, my lord. Next, my lord, they have reiterated, my lord, Hitendra Vishnu Thakur. Lordship, skip that part. Para 37, my lord. My lord has para 37.
Yes.
The same issue came up for consideration before the Constitution bench in this court in Sanjay Dutt. Specific submission was made before the Constitution that a notice to the accused of the application for extension.
Reiterated what?
Reiterated that, my lord, this written notice is not required. And because Sanjay Kedia went on, my lord, notice. So here it was clarified that in terms of Sanjay Dutt, my lord, written notice is not required. Production of the accused, informing him of this fact that application has been made for extension is there. Finally, the coordinate bench judgment of this honorable court, my lord, where also same issue had risen, my lord, and all of these judgments were considered, all the aforesaid judgments. And Chong Soi Howkeep, my lord, and para 17 eventually, my lord, after considering all the judgments, my lord.
Okay.
Para 17 it was quashed, my lord.
Okay.
So here also, my lord.
So your case is neither notice was there nor you were produced.
Not produced.
However, the period was extended.
Period was extended.
Yes.
Actually, it is apparent from the impugned orders that no notice.
Notice was not there.
Produced.
Okay. Heard Mr. S. Nawaz, learned counsel for the petitioner.
And item
Also heard.
the criminal petition where we have assailed the order, 35 is the bail application. Both same, fine together.
You have assailed the order?
In item 34, my lord, criminal petition.
34.
And 35 is the bail application.
Okay. 34, first 34. Heard so and so. Also heard Miss Endas Lanet, additional public prosecutor. This application under section 528 of BNFS has been filed by the petitioners, namely Anzar Hussain, impugning the order dated 3/6/2025, passed by London Special Judge Nogao in Nogao PS case number 1156/2024, whereby the period of detention of the present petitioner was extended beyond the period of 180 days under section 36A within bracket 4 of the NDPS Act. Learned counsel for the petitioner has submitted that the petitioner was arrested in connection with Nogao PS case number 1156/2024 under section
Under section 61(2)/123 of the BNS, read with section 21A/25/27A/29 of the NDPS Act with added section 21C.
21C of the NDPS Act. He submits that since the commercial quantity of contraband and section 21C was involved in the above aforesaid case, the statutory period of detention under section under section 36
A4, 36A, proviso to section 36, capital A within bracket 4.
Was 180 days. Is 180 days in this case. He, however, submits that after full stop, that on 177th day, the learned public prosecutor had filed an application for extension of the said period for another
180 days.
another 180 days. Stop. By impugn order dated
3/6/2000.
3/6/2025. The said order was allowed, the said prayer was allowed, and the period of detention was period of detention of the petitioner was further extended to 180 days more. Learned counsel for the petitioner has submitted that under section 24, under section 36A, within bracket 4, proviso to within bracket 4, the period of detention of an accused who is detained behind the bars for 180 days may be extended on an application, on a report of the public prosecutor indicating the progress of the investigation and the specific reasons for such extension of the detention period beyond 180 days. Stop. He, however, submits that the apex court in the case of Hitendra Vishnu Thakur versus Thakur and others versus State of Maharashtra and others, reported in 1994 4 SCC 602, has clarified that at the time of considering the application for extension in case of a detainee under TADA, the issuance of a notice to the said detainee was read into the provisions of
Section 20.
Section 20, clause 4, Section 20, clause within bracket 4 of the TADA Act. Learned counsel for the petitioner submits that Section 20 within bracket 4 of the TADA Act is in pari materia with Section 36A within bracket 4 of the NDPS Act. Same has also been reiterated by the apex court in the case of Sanjay Kedia
It was reiterated in Sanjay Kedia, clarified in Sanjay Dutt.
Sanjay Kedia, no, that perimeter part.
Oh, in Sanjay Kedia.
Sanjay Kedia, alias Sanjay Kedia versus intelligence officer, NCB and another, reported in 2009, 17 SCC 631. Learned counsel for the petitioner has submitted that later on, the apex court has, in the case of Sanjay Dutt versus state through CBI Bombay in the case reported in 1994 5 SCC 410 has clarified that the requirement of written notice is not there, though not there under section
24 of the TADA.
20 within bracket 4 of the TADA Act. However, while considering, however, the requirement of notice may be fulfilled if the accused is produced before the court when such an application for extension of his detention is considered. Learned counsel for the petitioner submits that since the provision of section 20 within 4 of the TADA Act is in perimeter with provision of section 36A within bracket 4 of the NDPS Act. Hence, at the time of considering the prayer for extension of detention beyond 180 days, at least production of the accused person is necessary. Stop. However, he submits that in the instant case, when the application for extension of period of detention was filed and when the impugn order was passed, neither notice was given to the petitioner nor he was personally produced before the court at that time. And therefore, he submits that the impugn order is in violation of the proposition of law as expounded by the apex court in the aforesaid rulings, and therefore it is liable to be set aside. On the other hand, learned additional public prosecutor fairly submits that from the materials on record and from bare perusal of the impugn order, it is revealed that on the date when the when the application for extension of period of detention was of the petitioner was filed by the public prosecutor, the petitioner was not produced before the court, neither on the day when the impugn order was passed, the petitioner was produced before the court. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for the petitioner in support of his submission. The law regarding compliance of principles of natural justice at the time of consideration of an application under section 36A within bracket 4 of NDPS Act for extension of period of detention beyond 180 days has been clarified by the apex court in the cases cited above. It also appears that though the apex court has in the case of Sanjay Dutt within bracket Supra has diluted the requirement of giving written notice to the accused at the time of consideration of an application for extension of his detention. However, it has been observed that the production of the petition of an accused at the time of filing of the application for extension of the period of detention as well as consideration of such an application is necessary. In the instant case, bare perusal of the record, impugn order as well as the order sheets available in the record would show that the petitioner was, when he was last produced,
Last produced, my lord, on second, like my.
no, petitioner was not produced
Produced on second or third, my lord.
before the court on 2/6/2025, when the application for extension was filed, extension of detention period was filed by the public prosecutor. Neither he was produced on 3/6/2025, when the impugn order was passed in this case. As such, this court has no hesitation to hold that the impugn order has been passed in violation of the guidelines laid down by the apex court in the case of in the cases cited herein above, namely Hitendra Vishnu Thakur Supra, Sanjay Dutt Supra, and Sanjay Kumar Kedia Supra. वो पूरा citation lana. The impugn order is accordingly set aside, and this criminal petition is accordingly allowed. Send back accordingly allowed. The bail application. Itu বন্ধ করছুন, বন্ধ করে দিয়ে cover to sabal. This heard same council. This application under section 483 of BNSS, item number, Kiman?
35.
This application under section 483 of BNSS has been filed by the petitioner, namely Anjar Hussain, who has been detained behind the bars since 8/12/2024 in connection with Nagaon PS case number 1156/2024 under section 61(2)/123 of BLS, read with section 21A/25/27A/29 with added section 21C of the NDPS Act. The gist of it, where is the FIR?
Where, my lord, page 12.
The gist of accusation in this case is that on
Relevant page 15, my lord.
on 7/12/2024, the one Sumitra Saikia had lodged an FIR before the officer in charge of Nagaon Police Station, Inter India, alleging that on receipt of that an information has been received through reliable sources that the petitioner and his associates are suspected to dealing with heroin and have procured the heroin from Dimapur and taking shelter near Polytechnic in a rented premises. Accordingly, a search operation was conducted in the rented premises. And how much heroin was,
My lord, initially, 0.98 grams of heroin was found, my lord.
and 0.98 grams of heroin was recovered from the possession of the petitioner.
Subsequently, my lord,
Later on, during the course of the investigation, how much?
and 532.46 grams of suspected heroin found in a vehicle.
Later on, during the course of investigation, 532.46
0.46 grams of
grams of heroin was recovered from a vehicle. Stop. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case on the ground of completion of the statutory period of detention prescribed under section
36A.
36A, read with section 487 of the BNSS.
180.
Huh?
187.
187,
Also, my lord, statutory bail, my lord.
statutory bail 487 of BNS. Learned counsel for the petitioner submits that the petitioner had completed 180 days of detention on 6/6/2020. 25. However, before the said date, his period of detention was extended on an application under section 36A within bracket 4 filed by the public prosecutor filed by the public prosecutor. ये sentence पढ़ना link failure हो गया. Stop. The said extension was passed on 3/6/2025 in
Nagaon PS case.
Nagaon PS case number
1156 of
1156/2024 by Learned Special Judge Nagaon. Learned counsel for the petitioner has submitted that the petitioner had impugned the aforesaid order by preferring a criminal petition which was registered at
criminal petition number
760/2025, and the said impugned order has been set aside by this court today itself, that is on 17 September 2025. And therefore, the petitioner submits, Learned counsel for the petitioner submits that as the petitioner, as the extension, no, as the order by which extension of detention of the petitioner beyond 180 days was granted has been set aside. The petitioner is entitled to go on default bail. The Learned additional public prosecutor submits that since the order dated 6/3/2025, by which the period of detention of the petitioner was extended beyond 180 days, has been set aside in criminal petition number 760/2025 by this court today itself. She has no further submissions to make. You have anything else? So I have considered the submissions made by Learned counsel.
Your Lordship, may I add? So eventually, charge sheet was submitted, which was after we had filed this bail application.
Okay.
That is also there in the record.
This bail application
Was
was.
filed prior to the filing of charge sheet. So our bail application was
Okay,
pending.
okay. It would be good. Counselor. Learned counsel for the petitioner has submitted that though this bail application was filed during the period of investigation. However, in the meanwhile, the charge sheet was laid
On 26/6/25.
26/6/2025. He submits that as the petitioner was entitled to default bail prior to laying of the charge sheet and has also filed the bail application seeking the default bail, he is entitled to get default bail. उसके बाद I have considered. Since the petitioner is facing trial in a case where inter alia offense under section 21C is involved, the maximum statutory period of detention under section 36A, read with section 487 of
And then do 187.
187,
Yes.
read with section 187, ऊपर भी 187 लिखो instead of 487. 36A of NDPS Act, read with section 187 of BNSS is 180 days. And since the order by which extension of period of detention beyond of the present petitioner beyond 180 days has been set aside by this court in criminal petition number 760/2024, the petitioner is entitled to get default bail in this case. Accordingly, the above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to following conditions. Trial condition. This
Satisfaction of learned special judge Mahal.
with to the satisfaction of learned special judge Mahal with following conditions. Trial condition. Dispose of both the cases.
I'm deeply aware.
Order item 44.
My senior is out of the.
Heard, Mr. What is your name?
M. Rahman, on behalf of.
M. Rahman, learned counsel for the petitioner. Who also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has prayed for an adjournment on the ground that conducting counsel for the petitioner is out of stature. The prayer is allowed. Let this matter be listed after Puja vacation on a date to be fixed by registry.
45.
May it please your lordship. My lord, here in this case, what has happened, lordship, although respondent number 1 and 2 does not appear, lordship, and 3 and 4 name reflected, lordship. But my main lordship prayer is against 3, lordship. So 3, lordship, name of the learned counsel for he was reflected in the post list of lordship. So at this stage, lordship, may I pray, lordship, kindly matter may be sent to the mediation, lordship, so that some amicable settlement may be.
What is the matter?
Sorry, lordship.
What is the matter involved?
Lordship, matter is relating to that, lordship. One proceeding was earlier initiated against me before the Court of Learned Chief Judicial Magistrate, Kolkata, lordship, regarding non-payment of loan amount, lordship. And that was already settled and withdrawn by the author, respondent number 3, lordship. Subsequently, again, out of same cause of action, lordship, he preferred another case, lordship, criminal case.
Where?
Before that, before the CGM, Kolkata law. Lord, and although Lordship, a notice under section 21 of the Arbitration and Conciliation Act was sent, Lordship, because there is a clause regarding arbitration law. But without appointing the arbitrator, Lordship, they straightway filed the criminal case against me. Because some Lordship,
This
amount
criminal case is under what provision?
earlier case was Lordship.
Yes, who is appearing for? You are appearing for
State of
state of Assam. State of West Bengal. Where is 3?
name
3 is
reflect-
required.
Yes, Lordship, name was reflected, Lordship, but
Whether notice has been served.
notice served, Lordship, and 3 Vakalatnama already filed, Lordship. In the cause list, name also reflected, Lordship, for respondent number 3, Lordship. Because 3 is the main party, Lordship.
Let 3 appear only, then we can think of, in his absence, how can we send it to me?
Name is reflected here, Lordship. So on next date, your Lordship may observe, Lordship, because on next date, if no one appeared, because they have already filed the Vakalatnama and appearing.
Now, whether this criminal petition can be sent for mediation. That main matter may be sent for mediation. This cannot. That is pending in Kolkata.
That may be because, Lordship, the dispute which arises, Lordship.
Okay, no, today we are
Yeah,
adjourning.
yes.
Let 3 appear.
Yes.
Heard Mr. W. Rahman,
NH Board.
NH Borbhaya, learned counsel for the petitioner. Also heard Ms. P. Bhattacharya, learned counsel appearing for respondent number 4 within brackets state of West Bengal. Though name of Mr. M. Sharma and Ms. S. Yasmin are shown in the cause list as engaged counsel for respondent number 3. However, no one has appeared when the matter was called. Since the main dispute in this case is in between the petitioner and respondent number 3, the presence of counsel of respondent number 3 is necessary for adjudicating this matter. Accordingly, let this case be listed after Puja vacation.
My Lord, on 16th, Lordship, 16th of October. Lord.
On 17th of October.
Of like.
56.
The state has prepared this appeal, Lordship, against acquittal, Lordship. And this,
Notice will go.
yes, notice will go, Lordship. Leave petition.
Heard Mr. B. Sharma, learned counsel for the petitioner. This application under section 419 / within bracket 3 of BNSS has been filed by the state seeking leave to prefer an appeal against acquittal against the judgment dated 9/6/2025 passed by learned special judge Assam, whereby the opposite party was acquitted in ACBPS case number 14/2015. Issue notice to the opposite party. The petitioner shall take step for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
47.
The IA has been filed for suspension of the sentence and allow the applicant on bail. The applicant was convicted under section 324/307 IPC and sentencing 2 years with fine of rupees 2,000
Sentence to what is the sentence?
Malata 2 years and fine of rupees 2,000 under section 324 million. And 5 years with fine of rupees 3,000 under section 307. In this case, my lord, lordship may kindly turn to page 83, my lord. The injuries are simple in nature. There are some, my lord, multiple injuries, but all the injuries are, my lord, simple in nature. Page 83, the observation of the, my lord, trial court.
Putul,
In the IA,
I,
IA is there, my lord.
this is I. Yes,
Yes, my lord. Page 83, my lord.
okay. Then what is your submission?
My lord, my submission is that, my lord, the trial court observed that, my lord, all the injuries are simple, and it is the, my lord, PW7 who is the, my lord, MO. It appears that the nature of the injuries are simple and not grievous one. Therefore, section 326 of the IPC cannot be invoked in the instant case, although the charge was framed under section 326 IPC. However, the lesser punishment under section 324 of IPC may be imposed against the A1, as the prosecution has fairly proved that A1 had assaulted PW5 and PW6 with a sharp weapon. There is corroboration from PW7, who is the MO of the instant case. Although the PW7 stated in his cause.
Now, what is your submission?
My submission is that, my lord, during pendency, he was, my lord, in jail about 3 months, and after, my lord, judgment, that is 1/17 to 2025, he is in jail, and, my lord, total about, my lord, 10 months. And he is the only, my lord, earning member of the family, my lord. And since, my lord, there is no case, my lord, under section 307, my lord, and it is convicted under section 307 also. But my submission, people lost, my lord, it can be converted under section, my lord, 324.
Okay. Yes, Mr. Sharma. I allowing. Heard Mr. D.A. Kayum, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed by the, where is that application?
The IA number, my lord, 362 of 2025.
Has been filed under section 430 of BNSS by the applicant Gulzar Islam Ali, praying for suspension of sentence imposed on him by the judgment dated 17/2/2025, passed by learned additional session judge Dhubri in sessions case number 55/2022, whereby the applicant was convicted under section 324 of IPC and was sentenced to suffer rigorous imprisonment for 2 years and to pay a fine of rupees 2,000, and in default of payment of fine to suffer further rigorous imprisonment for 1 month. The applicant was also convicted under section 307 of IPC and was sentenced to suffer rigorous imprisonment for 5 years and to pay a fine of rupees 3,000, and in default of payment of fine to suffer rigorous imprisonment for 2 months. Learned counsel for the petitioner has submitted that the petitioner has impugned the aforesaid judgment by filing a connected criminal appeal, that is criminal appeal number 127/2025. The said appeal is admitted for hearing. He further submits that the trial court has observed in the impugned judgment that the injuries sustained by the victim are of simple nature and therefore, comma, there is every likelihood of conversion of the conviction under section 307 of IPC into either 323 IPC or 324 IPC. He therefore submits that since there is a hope of getting favorable order in the connected criminal appeal, and since the sentence imposed on the petitioner is a short-term sentence of 5 years only, unless the execution of the sentence imposed on the applicant is stayed during the pendency of the connected criminal appeal number 127/2025. The said appeal may become infructuous and the petitioner in that case would be highly prejudiced. Stop. Considering the submissions made by learned counsel for both sides, this court is of considered opinion that since the appeal filed by the petitioner impugning the judgment has been admitted for hearing, and considering the number of criminal appeals pending before this court, it is unlikelihood of that appeal being listed in its due course at the earliest. Hence, unless the sentence imposed on the applicant by the impugned judgment is suspended during the pendency of the said appeal, he would be highly prejudiced. So accordingly, the sentence imposed on the applicant by the impugned judgment is hereby suspended till the pendency of the connected criminal appeal number 127/2025. Stop. The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount in connection with Sessions case number 55/2022 to the satisfaction of learned additional session Judge Dhubri, with a condition that in the event of dismissal of the connected criminal appeal number 127/2025, the petitioner shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment. This interlocutory application is hereby disposed of. In bail application, in main criminal petition, same counselor naam likhimo. This appeal is admitted for hearing. Let it be listed again after 8 weeks. List accordingly.
48.
Like the POXO appeal matter, we have taken steps upon the respondent number 2 on 13/5/25. So, madam, perhaps the learned PP might be able to produce the instruction.
Yes, you seek instruction.
So I have not seen the official, whether it's official is there in the IA.
I saw. Office note asen and instructions.
Because notice issued long back, 5/5/25.
13/5. Second steps. Okay, 5 seconds.
Acceptance notice. And
Then
এই থার্ড ফাইলটো থাকিব লাগে একদম থার্ড ফাইলটো থাকিব লাগে
Supplementary file at the
থার্ড ফাইল
No. No, this is acceptance notice by the PP.
from our then my lord,
From the
Let them have the instruction.
we will take instruction.
Okay, heard Mr. S. Das, learned counsel for the appellant slash applicant. It appears that the applicant slash appellant had taken steps for issuance of notice on respondent number 2. However, no service report has been received till date. Stop. Under aforementioned circumstances, Mr. K.K. Parashar, learned additional public prosecutor, is requested to take information regarding the fate of notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date. 5th. When?
23.
Let this matter be listed on 23rd of September.
Value.
Accused petitioner along with another accused has been convicted by the learned session judge under section 307 and the 326 and 115 of the IPC, my lord, 147. Awarding 5 years imprisonment under section 307 and 3 years under section 326 and 15 days under section 141, my lord. The appeal is already admitted, my lord. And also as called for, we have filed an IA application. We have filed an IA
Yes, sir, I
application
said.
for suspension of this under section 389 CRPC, new code 400, for suspension of the sentence and releasing the accused on bail. Earlier court has ordered that it will be considered after receipt of HCI. Today HCI is received, my lord.
Okay.
The point is that when the conviction is less than 10 years, your lordship can grant bail even without public prosecutor under section 389. my lord. There are provisions, my lord. 389, old code, new 400, my lord. Same language.
That is some.
89, my lord, suspension of sentence pending the appeal, release of the appellant on bail. Pending an appeal by the convicted persons, the appellate court may, for reasons to be recorded by it in writing, order that execution of the sentence or order appeal against be suspended, and also if he is in confinement, that he be released on bail on his own bond. They provided that the appellate court shall be for releasing on bail on his own bond and conviction person who is convicted of an offense punishable with death or imprisonment of life or imprisonment time not less than 10 years shall give opportunity to public prosecutor so in the court. In case of 10 years or death or life, my lord. The less than 10 years, the public prosecutor is not required to be heard, my lord. By recording reasons, your lordship can grant bail. The reason is that because he is already on bail, the trial court, my lord.
You are on bail.
My lord.
Now you are on bail or you are behind the bars.
No, now he is on the date of judgment, he was remanded to the jail.
Okay, in main appeal,
He is in
likhebo,
jail, so we are filing petition for.
heard Mr. K. Sharma, learned counsel for the appellant. Also heard Ms. N. Das, learned additional public prosecutor. The office note dated office note dated 4/9/2025 shows that The records of the trial court have been received. The AD card in respect of notice issued to how many remaining respondents? Two remaining respondent has been received. Therefore, this case is ready for hearing. List this matter for hearing after 8 weeks. I heard Mr. Kesh, you have anything? 5 years only. Heard Mr. K. Sharma, learned counsel for the applicant. Also heard Ms. N. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, namely Monique Antonath, under section 430 of BNSS, praying for suspension of sentence imposed on him by the judgment and order dated 29/5/2025, passed by learned Session Judge Vishwanath, convicting him, whereby the petitioner was convicted along with one another co-accused under section 307/326/341/34 of the Indian Penal Code. The petitioner was sentenced
5 years.
to undergo rigorous imprisonment for 5 years under section 307 IPC. He was also sentenced to pay a fine of rupees 10,000 and in default of payment of fine to undergo rigorous imprisonment for simple imprisonment for 3 months. The petitioner was also convicted under section 326/34 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 5,000 and in default of payment of fine to undergo simple imprisonment for 1 month. He was also convicted under section 341 and was sentenced 341/34 and was sentenced to undergo simple imprisonment for 15 days. Learned counsel for the petitioner has submitted that the petitioner has impugned the aforesaid judgment in connected criminal appeal number 235/2025 and is hopeful of getting a favorable result in the said appeal. Stop. He, however, submits that since the petitioner has been sentenced to a short-term imprisonment of 5 years only, hence, unless the execution of sentence imposed on him by the impugned judgment is stayed till during the pendency of the connected criminal appeal number 235/2025, he shall be highly prejudiced. Stop. I have considered the submissions made by learned counsel for both sides. Since in this case, the appeal filed by the petitioner has already been admitted for hearing, and since the sentence imposed on the petitioner is a short-term imprisonment of 5 years only, this court is of opinion that this is a fit case to invoke the powers of this court under section 430 of BNSS and to suspend the sentence imposed on the petitioner during the pendency of the connected criminal appeal, which this court accordingly does. Stop. The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount. Subject during the pendency of the connected criminal appeal, subject to the satisfaction of learned Special Judge Vishwanath, with a condition that in the event of dismissal of the connected criminal appeal number 235/2025, the petitioners shall surrender before the trial court to serve out the remaining portion of the sentence imposed on him by the impugned judgment. This interlocutory application is accordingly disposed of.
Most obliged.
Wait, Your Lordship. Lordship, there is an IA for suspension of sentence, Lordship. The matter relates to section 8 of the POSCO Act.
Section
8 of the POSCO Act, Lordship.
POXO is there.
Lordship, in the last occasion was pleased to appoint an amicus. Lordship, Mr. S. Nawaz used to represent the matter.
You're
They've
right.
been served a copy, Lordship, and there is a compliance report as well, Lordship. The IO was in terms of the notification of 70, Lordship, the procedure prescribed. Notice has been written, Lordship. There is a compliance also. From the IO, Lordship, regarding objection of this release on bail.
They file, anybody has filed objection,
No, there is a
but
compliance.
you are objecting.
Lordship, 3 years.
3 years.
period.
Okay.
Please.
Okay, heard Mr. H. Petala, learned counsel for the applicant in IA. Heard Mr. H. Petala, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. S. Das, appearing on behalf of Mr. S. Nawaz, learned legal aid counsel appointed for the respondent number 2 / informant. This application under section 430 of BNSS has been filed by the applicant / appellant, namely Shri Chandra Sharma, praying for suspension of the sentence imposed on him by the judgment and order dated 15/5/2025, passed by the Court of Learned Additional Session Judge, Special Judge POXO, Kamrup Metro, in Session Special Case number 193/2023. By the said judgment, the applicant / appellant was convicted under section 8 of the POXO Act 2012 and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 55,000, and in default of payment of fine to undergo further rigorous imprisonment for a period of 6 months. Learned counsel for the applicant / appellant has submitted that the applicant has impugned the aforesaid judgment by preferring a connected criminal appeal number 267/2025, which is admitted for hearing. He also submits that since the applicant has been convicted for, he also submits that the applicant is hopeful of getting a favorable result in the connected appeal filed by him. He, however, submits that since the sentence imposed on the petitioner is for a short-term period of 3 years only, unless the state sentence is suspended during the pendency of the connected criminal appeal, there is a likelihood of his criminal appeal becoming infructuous if sentence is allowed to run concurrently during the said appeal, and the petitioner would be highly prejudiced by the said fact. I have considered the submissions made by learned counsel for both sides. The connected criminal appeal number 267/25 has already been admitted for hearing. And since the sentence imposed on the applicant/appellant is for a short period of 3 years only, this court is of considered opinion that this is a fit case where powers under section 430 of BNSS may be invoked to suspend the execution of the sentence imposed on the applicant during the pendency of the connected criminal appeal, which this court hereby does. You are on bail?
No, Lordship.
You are in jail?
No, Lordship. The period of extension of this bill, Lordship, that expired and NBW has been issued by the court below, Lordship. So we'll have to go on a fresh bill, Lordship.
The petitioner is also allowed to, in the meanwhile, during the pendency of the connected criminal appeal, the petitioner is allowed to go on bail of rupees 30,000, subject to the satisfaction of learned additional session judge, come POXO judge, come special judge POXO, Kamrup Metro, with a condition that in the event of dismissal of the connected criminal appeal number 267/2025, the petitioners shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment. This interlocutory application is accordingly disposed of. In main case, heard so and so, the trial court records have been received, and this appeal is ready for hearing. Let this appeal be listed for hearing after 8 weeks.
I deeply obliged, Lord. 51.
May it please the Lordship. My lord, I am the applicant in the IA, my lord, and the sole respondent in the connected criminal revision petition. My lord, the revision petition is filed by the convict, my lord, who has been sentenced for 6 months simple imprisonment and 6 lakhs of fine, my lord, in NI Act case, my lord, check bounce case. So, my lord, the IA is filed, my lord, claiming compensation, interim compensation under section 143 A of the, my lord, Negotiable Instrument Act, my lord. Wherein it is held that at least 20% of the fine amount by an appellate court and 20% by trial court may be, my lord, released to the victim complainant, my lord. And in this regard, my lord, I will submit
Yes. What is your submission? Let them file a objection.
I have
Heard.
submitted an order of the Honorable Court. in
No,
another
power
case.
is there, but let them say what they have to say.
Obliged.
Heard Mr. M.J. Kadir, learned counsel for the petitioner. Also heard Ms. A. Begum, learned counsel for the opposite party. This interlocutory application has been filed by the applicant, who is the respondent in connected criminal revision petition number 233/2025. Praying for directing the opposite party for payment of interim compensation in terms of section 143A and 148 of the Negotiable Instrument Act. Learned counsel for the opposite party, on the other hand, prays for some time to file an affidavit in opposition in this case. A written objection in this case. The prayer is allowed. Let this matter be listed after puja vacation on a day.
Otherwise, it is a statutory provision by that. And the objection. But they are not allowed, my lord.
They may file objection.
And when in this case, when on the very first day, when I have provided the order.
After,
Motion, my lord.
kitya dile?
My lord, a date may be given, my lord. He is suffering from a neurological problem, my lord.
Dated on 22nd October.
But 2 days earlier may be given, and that day some problem is there, my lord.
Believe them, 17th
17
October.
of like.
52.
May I please, your lordship? Your lordship, this is an IA for delay of condemnation, your lordship.
Will issue notice. Delay condemnation. Who is the party? State.
State is the party, your lordship.
How much delay is there?
304 days, your lordship. Your lordship.
Yes, Mr. Sharma. Not objecting. Heard. Miss B. Soren, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant, namely Rafiqul Islam, alias Afiqul Islam, who is praying for condonation of delay of 304 days in filing the connected criminal appeal. Whereby the applicant intend to impugn the judgment dated 8/8/2024 passed in sessions case number 349/2018 by learned additional session judge Dhubri. Whereby the applicant was convicted and sentenced under section 370 of the Indian Penal Code. Learned counsel for, where is the reasons? Reasons for delay.
Your lordship, his wife belongs from illiterate family and socially and economically.
Which is the para?
Your lordship, para 4, your lordship.
Learned counsel for the petitioner has submitted that in paragraph number 4 of the condonation of application for condonation of delay, the petitioner has stated the reasons for approaching this court beyond the period of limitation. Consider learned additional public prosecutor has not objected to the prayer considering the grounds shown for the delay caused by the applicant. I have considered the submissions made by learned counsel for both sides. Since the grounds shown in the application for condonation of delay for approaching this court 304 days beyond the period of limitation is found to be sufficient ground, the prayer for condoning the delay of 304 days is hereby allowed, and this interlocutory application is accordingly allowed. The registry is directed to register the connected criminal appeal and list the same for admission on a date to be fixed by it. Bail only after registration of file.
The petition is coming more than order farm. The date before petition.
Heard Mr. M.K. Das, learned counsel for the petitioner, who submits that this matter has been wrongly listed in admission column and it ought to have been listed in the motion column. Since due to paucity of time, this matter could not be taken up today, let this matter be listed in the next week on a date to be fixed by registry. Rest matters,
May I please also, item number 53, next item lordships. 53 lordships, only 15 days delay lordships for preparing appeal lordships. And that may be condoned. There is the party lordships. That may be condoned. 53. Only 15 days lordship, that may be condoned lordships.
no, 15 days is
50.
not the matter. Matter is we are running out of time.
Next item was there lordship.
You have any objection?
Only 15 days. There is the party lordship, police is the party lordships.
We'll list this tomorrow.
Only 15 days. I said.
Wildlife lawyer, the council has to be present. What is the item number?
53 lordships.
53.
Lordships.
Due to paucity of time, the matter could not be taken up. Let this matter be listed day after tomorrow.
After bailing.
Then it will go after puja vacation.
No.
Then we'll hear
Tomorrow lordship.
rest matter. You pray before registry. I have requested the registrar to accommodate all of you.
I'm obliged.
After the 4 kilo is matter listed. And lordship, 2 days earlier, this matter was listed. And just a report has been called. And report already received, lordship. So lordship, this matter will be taken care of.
What is the item number?
Item 59, lordship.
59 day after tomorrow.
Lordship.
Registry.